I beg to mention, my lord, for listing criminal petitions too, my lord.
Criminal petition, make a mention tomorrow. This is a division bench right now. In division bench, you can take criminal
In
petition.
division bench, my lord, I am playing to upgrade item 16 because person is in detention camp.
Item
16, 1/6,
16.
my lord.
Okay, we'll consider.
I am deep.
May it please, Lordship. Lordship, item number 7 may kindly be taken at 2. The engaged counsel will cut
At
it
2, we may not be sitting in the division bench.
for the time, Lordship.
Item number?
7.
Okay.
Obliged.
May I please, your Lordship? Lordship, I beg to mention item number 9. Both the senior cane shooter in Hpurago are out of station.
Okay. Both sides are represented on the prayer made by the counsel for the petitioner. Matters is adjourned today, placed after 2 weeks. Yes.
Highly obliged.
May I please, your Lordship? Lordship, I beg to mention item number 15, Lordship. 15, 15, Lordship. So may I pray for abrogation of this matter, Lordship?
Item?
Item number 15, Lordship, 15. There is an IA, he is behind the bar for 7, behind detention, Lordship, for 7 months.
Okay, this. Okay, I'll try.
Obliged, ma'am.
Item number 1 for motion.
The time this has to go back. Notice was hanged in a local club.
My lord, your lordship may pass note and wish. Let him be present. Otherwise, my lord, again, it will be an expertise there. There may not be any knowledge. So, in presence of learned counsel, my lord, if your lordship pass note.
Okay. After some time. Yes, item 2.
May I please, Lordship? Kindly pass over the matter for time being, Lordship. My senior is on leg. Item number 2 and 3, Lordship.
But issuing notice will not give bail in this case. 2021 opinion. Your name?
MS Mondal.
MS?
Mondal.
Mr. MS Mandal, learned counsel to the petitioner. Respondents are there. Page 64 is the imperial order. The 27/1/2021. Due to inordinate delay in approaching the court, keeping the issue of maintainability open, issue notice returnable in. Give a date after 4 weeks. Returnable on so and so. Requisite extra copies of the writ petition be served on the learned CGC, State and Departmental Council within 2 days. As we call for the relevant records from the concerned tribunal. Next paragraph. In view of the inordinate delay in approaching the court, comma, the prayer for bail shall be considered on receipt of the records of the tribunal. List on so and so.
Item number 3, Lordship.
Item 3,
Same order. Here the
1009.
opinion is page 78. Same order, not any delay. Same order we are passing.
Obliged.
item 4,
May I please, Lordships. The expertise order passed on my lord 5922, my lord. My lord, I have not received the notice, my lord. So kindly have a look at page,
You-
my lord.
You file a case against your husband.
Not filed, my lord.
You file a case against your
Yes.
husband. Your husband did not communicate to you.
Well, some since 2020, my lord. Some
I don't know,
earlier also,
perhaps
my lord.
some court will also give, will send him to jail for doing so. Bail will be considered on receipt of records, not now. See what Mr. has somewhere. Counsel for the petition.
Apparently, my lord, if notice.
We are
Notice is
issuing a
clear, my lord.
notice. We are issuing a notice. We are calling for the records, but bail will be considered on receipt of records. Here don't give inordinate delay. Maintainability is not required. Then dated 5/9/2022. Which page?
Page 38,
38.
PH.
Five nine 2022. It will be considered on receipt of records. We are issuing notice, extra copies within 2 days.
Fixing,
The date, same date.
my lord.
28/5.
Oblige me.
Supplementary item 16 for motion.
May I please, your lordship. Lordship, opinion of the tribunal is, my lord, page 103, dated 6/3/2025, my lord. On that day, my lord, petitioner appeared and he was taken into custody. 6/3. The record was called for, my lord, for bail.
Which is the best document you have to connect you to your projected parents?
That is, my lord, the voter list of,
No voter list. Any other good document?
voter list, my lord, I have.
Voter list, you may have certified copy of the voter list of the chief minister. It is available in the public domain. You may have anybody's XYZ, anybody's voter list with you. Show us a good document to connect you with your parents. Any voter list you have with your own father and mother?
My lord. It is, my lord, page 156.
156.
56. My lord, Procedural is the father, Fulgan is the mother, Abu Bakr is the petitioner. One 57 is the partner. One 58 also, my lord.
Sign number তোমার দিদি শুনে চলার মতো 25
Like 162. All family, my lord, my father, mother, and my brothers.
Exhibit 7 is extra photocopy of voter list. So submit photocopies. Original name.
Item number 9 only. Eh? 9. Only 9. Forum, no? No, okay, fix.
Yes.
For the purpose of bail,
Apparently, Mother, there is the petitioner and in fact, the father of the petitioner could not establish that their grandparents are their along with their grandparents. Mother. That is the issue, because the father's name is appearing. In fact, he has not submitted numbers of documents in the tribunal. The 2010, Mother, which your lordship he has placed down, this was not exhibited before the tribunal. This was not exhibited before the tribunal at all. They exhibited only the 1951 Malot NRC document photocopy, then 1966 voter list, then 1970, then 1997, then 2005 and 2015 and 2023. Now he has annexed some certain documents in between period Malot of 1970 to 1997. This has created more doubts. That's why they did not exhibited the documents, these documents, my lord. That's why probably they did not exhibit it intentionally. Because if we see in between documents of 19, my lord, it's a huge difference of age. The fathers and mothers in the mother's name. Madam. If your lordship may kindly see page 146 up from 144 onwards. This is the 144 voter list of 1989. This has not been mentioned by the petitioner nowhere. Now they have annexed here, my lord.
page number
Page 144, man.
144 is exhibit 2. Oh, just a moment.
No,
Just a moment.
144 is voter list of 1985, man.
Just
This was not exhibited.
Yes, 144.
Yes, your lordship may kindly see 145. The last two, my lord, the entries. One Messer Ali was there, son of Sonallah, aged about 43 years, and one Puljan Bibi, Messer Ali, wife of Messer Ali, she was 28 years. In 1985, my lord, and this was in the village of Kantanga at South Salmora constituency. Similarly, my lord, 147, this is a voter list of 1989. This is there in page 147, last two entries, my lord. Messeruddin, whom she is trying to project as further, and Puljan Nessa. Here age is 43 and 30. Now, if these two persons are the same person, my lord, in 2010, 157 is in a different village in different constituency, my lord. In page 157, my lord. Messer Ali, after 20 years, he become only 5 years older than the my lord 1980. Messer Ali, your father is Sonaula Munshi. It's not Sonaula, Sonaula Munshi. Village is different. My lord, the constituency is different. Age is totally not matching along with the earlier two persons. The 24 and 25 entry. Now, can we say these two persons are the same person whose name were enlisted in 1940, 89, 85? That's why they did not, because there is huge contradiction in age, names, and delays and etc. That's why they did not submitted the document in the tribunal. And in fact, this document was also not submitted. Only 2015 voter list was submitted. The next page 159. And in fact, they have filed review of that opinion. In fact, in review also, they did not mention all these documents. They did not place these documents before the tribunal. Now, for the sake of argument, if we accept that this 2015 documents is correct, suppose we accept that 2015 document is correct, and Messer Ali son of Sonaullah Munshi, and Fuljar Nessa, my lord, son of, is the mother of Abu Bakr Siddiq. My lord, if we accept also, then we have to see whether Messer Ali was there prior to 1971 in the state of Assam or not. To establish his citizenship, my lord, that has to be seen. Now he has to establish that his father or grandfather was there in 1971, my lord. So where is the link of this Messer Ali along with that part, my lord, Sonaullah Munshi or Sonaullah, who was there in 1966 in some other village, in some other constituency, in absence of those documents which were not placed before the tribunal, my lord.
See the voters list of 1970, 71.
Yes.
Which page is that?
142, my lord. 762.
The 142. The particular is
143.
yes,
Pata Kata.
Katakata. Dokin.
Patakata is the Dagghar, my lord.
My lord, this is
Katdanga,
Katdanga.
village
Katdanga. Katdanga is the village.
Kadanga.
Yes. The Dokin Salmora. Yes. Constitution was 31 Mankasar.
Yes.
Now, in 85 also, it is Katdanga. If your lordship may kindly see 144, 145. These are not exhibited documents, 144, 146, 147. So in absence of this 140, this voter list of 1989, 90, 89 and 85, the link between the father and grandfather is not there.
No, 97 is there.
97, yes, 97 is there, but 97 father and mother is not voter. Why did it not produce these documents where they were appearing together in a common voter list? They did not produce these documents. This is a calculated game where they did not place these documents. And only 97 voter list is produced. 97 where the father is not voter in, father and mother, grandparents are not voter in 1927. And surprisingly, if those two
Mr. Payang,
Well,
we'll take it up on Friday because we have to go through it, all the documents, and I
Yes.
appreciate that what you are saying. We'll consider a bail on Friday. But Mr. M.R. Khandagar, counsel for the petitioner. The respondents are there, Mr. A. Kuli on behalf of AILA. Pursuant to order dated 1/4/2025, the records of the tribunal is received. First of the perusal of the records would take some time. So accordingly, the court is inclined to issue a issue notice returnable on Friday, 2/5/2025. On first, 1/5/2025. Without requiring any first steps to be taken. You have received extra copies?
Yes.
Okay. Just to accordingly list in the admission column on 1/5/2025. Both. And in IO, you say the prayer for bail shall be considered on the next date of listing, list on 1/5/1995.
Supply item 17 for admission.
Yeah. Select no.
Not admission, motion, my lord.
Yes, this is motion matter.
One.
मैं सबमिट करना चाहिए
Yes.
Look, I'm a Nigerian citizen. I've been in I was arrested on 12/11/2020.
Okay, we issue a short notice here.
Lordship.
He's completed his sentence, he is saying.
Yes, sir. My
On
lordship,
13/5/21, sentence was completed.
notice me, go and, your lordship, sir, record the name RKD Chaudhary. Union India is main party. Their deportation and other power as with Indian.
So you need who is representing? Acha. Just give a scroll for this CCC. CCC can scroll. Take it after some time. Let CCC come. DSG of the CCC.
Yes, I will.
After some time.
Daily list item 5 for admission.
Yes.
Lordship, this is a case where petition has been declared for an expert proceeding loss. In order is that lordship pays 31. Yes, 31 lordship. Yes, 32 second para is the most relevant lordship.
Notice has appears to have been duly served on you or your wife.
Yes, lordship. Notice has been served to my wife, lordship,
Yes.
and I was not at home, lordship. I was never working in Guwahati, lordship. And I have taken mainly, lordship, the plea
That
that,
means you don't take care of your wife.
lordship, I have taken a plea that the notice issued by the learned tribunal.
Had you respected her, she would have not done this.
Actually, lordship, my wife is also an illiterate person, lordship, and the notice served in the language of English, lordship, and my plea is that the official language of the state has not been used, lordship, as mandated, lordship, by law, lordship. Otherwise, I have documents sufficient to, lordship, prove my citizenship. Notice is lordship at page 27, lordship. Type copy lordship, original is 2030 lordship. my lord.
Mr. Sharma,
Lordship, it is a, it's not the case that Lordship, he did not aware about the proceeding Lordship. And initial reference was, earlier reference was initiated in the year of 2001, Lordship. Since, so Lordship, he is very much aware about the proceeding Lordship. And after that, such kind of commonly is taken by, in each and every petition Lordship, such type of plea has been seen Lordship.
no, he's taking a plea which is there in paragraph 3(4), that the notice must be in must be in English and official language.
Five A Lordship, Foreigners Tribunal Order 1964, 5,
Yes, 5A.
5A,
No, 5A.
35A.
Yes.
The notice shall be served at the address where the proceeding last resided and reportedly resides or works for gain.
No, 3(4). 3(4), the notice shall be in English and official language of the state. This is the plea he's taking.
Yes. The notice shall be served in English and also in official language of the state, indicating that the burden is on the proceeding. Yes, Lordship.
This is the plea he's taking.
Record to আহিছে নেকি?
In your writ petition, which is the best document to show your connection with your parents and your stay before 1971?
1971 Lordship. Start from 1966 Lordship, page 36 Lordship. This Amaton Nessa Lordship, wife of Rahman. He is my grandfather. She is my grandfather Lordship. Grandmother, sorry. Grandmother. Then Lordship 1971.
Receipt of different village Lordship and Kanu Mia projected father of the proceeding aged about 50 years. His name should be reflected in earlier voter list of 1966.
This is a Lordship, adjacent village Lordship, Katlijar. And the next voter list 1971 Lordship,
Yes,
page 38 Lordship.
yes.
Here his father's name Lordship, at serial number 892 lordship. And mother's name?
No, cannot
490.
be, that cannot be your father.
There is discrepancy regarding
No, you see, page, you are showing us page 37,
lordship.
37 Amatan Nessa.
Abdur Rahman.
And serial number 4 is or Rahman. It can be Abdul Rahman, but
Yes.
it can be anything else. So therefore, this Amanatan Nessa is either the wife or the daughter of Abdul Rahman.
Right.
Now come to page 39.
Lordship.
Kanu Mia is also the son of Abdul Rahman Mia.
Mia lordship.
So you are this can't be brothers and sister, can't be a married couple.
No lordship, he is son of Abdur Rahman Mia, that Kanu Mia lordship.
And Amaton Nesa's name is not here in 1971.
And Amaton
Here it
Nessa,
is Kanu Mia. Who is Kanu Mia then?
Kanu Mia is my father. And he is the
He-
son of Abdur Rahman.
Abdul Rahman.
Yes.
And then Amatan Nessa is also son or
No,
wife
lordship.
of Abdul Rahman.
Wife of. It would be wife of lordship.
Is the wife of.
Yes, ma'am. And lordship, the second, Mulukjan Nessa is my mother.
Where is that name?
Next name, lordship, that is number 39, lordship, 38, 39, lordship. Mulukjan Nessa, second lordship, 493. Serial number, lordship. Is my mother, lordship. Sohar Ali is my brother. Not brother, lordship, sorry, paternal uncle, lordship, paternal uncle. Sohar Ali is my paternal uncle, lordship. Next, lordship, may kindly see the page 42, lordship. This is a registered sale deed, lordship, where my mother purchased a plot of land, lordship.
In the year of 1985.
85. At village Naparjar, lordship. There was a proceeding against my mother also, lordship, under IMDT, lordship.
Where is the opinion?
Opinion is a lordship, page 51, lordship. Here that 1966 voter list was produced, lordship, before the learned tribunal, in that case, lordship.
Where is my appreciation of that? Yes, it's locked.
This will be available with whom?
Lordship.
Empty
Maybe.
record.
He had Lordship, Forest Tribunal, #1, Borpeta.
Borpeta.
Probably Lordship.
Also is a representative. Next paragraph, Mr. J. Abbas, Land Counsel for the petitioners, referred to an opinion dated 1/10/1991 within bracket, lecture H, bracket closed, passed by the Foreigners Tribunal, Borpeta, in FT case number 234/90, within bracket B, capital B. Full stop. By referring to the same, the learned counsel for the petitioner projects that his mother was declared to be not a foreigner. Full stop. The court is inclined to call for the said records and examine the same. Full stop. Accordingly, the registration send a requisition to the learned member, Foreigners Tribunal, #1, Borpeta, in respect of FT case number 234/90, decided by opinion dated 1/10/1991. Next, but apart from regular requisition, the requisition shall also be sent to the following email address of the said learned tribunal. Next para. List on 18/5/2025. Just check the address and give it.
Eighteen five, lordship.
Hmm?
18.5, I think is 100. 18,
16/5.
sorry, 16.
No? 16.
Loss. Sorry, loss. Biblioblex.
Mr. Sharma,
Lordship.
this is an old record. They'll be able to locate it and send it by then. We are giving 3 weeks, 2 weeks time.
Lordship, I will try Lordship.
They can do it.
Lordship.
Okay. Item 17.
Time being item 17.
Yes. You're issuing a notice of a week, within a week, because it's illegal detention now. Heard Mr. D.K. Agarwal and counsel for the petitioner. Also heard Mr. A.R. Adhikari, learned CEC appearing for respondent number 1, and Mr. P. Sharma, learned additional senior government advocate appearing for respondent number 2. Next para. The petitioner is a citizen of Federal Republic of Nigeria. He projects that during the outbreak of COVID 2020, he was in Bangladesh and he crossed into India from Bangladesh through Karimganj in November 2020, projecting that he had an intention to travel to the Nigerian embassy in New Delhi to travel to his own country. He was apprehended on 12/11/2020 and was taken into custody and sent to the and produced before the concerned court on 13/11/2020. The petitioner was convicted by order dated 18/8/2021, passed by the learned Chief Judicial Magistrate First Class Roman 2, Karimganj, to undergo simple imprisonment for 6 months and to pay a fine of rupees 2,000 for offence under the under Section 14 of the Foreigners Act, 1946. And he was also sentenced to undergo some simple imprisonment for 6 months and a fine of rupees 2,000 for offence under Section 6 of the Passports within bracket entry into India bracket close rules, 1950. Most of the fine was it with default stipulation, and the sentences were ordered to run concurrently. Accordingly, it is projected that the petitioner has already served his sentence on 13/5/2021. However, is still in lodged in transit camp, Matia Gwalpara, since 12/3/2023. Next para. As it is projected that against a sentence of imprisonment for 6 months, the petitioner has spent more than 1608 days in detention. Court is inclined to issue notice returnable within a week. Full stop. Next, as the learned CGC as well as the learned additional senior government advocate has received accepts notice on behalf of respondent numbers 1 and 2, requisite extra copies of the requisition be served on them in course of the day. Next para. The as the next para, as the petitioner has annexed a photocopy of his passport at annexure 5 of this writ petition, comma, the learned CGC shall send a scanned copy of the said passport to the, who will be there, MHA or Ministry of External Affairs will take up the matter.
MHA is not a party here, my lord. I think, my lord, even the Minister of External Affairs has to be made a party here.
That we pass an order.
My lord,
That's why we are passing an order,
yes, my lord,
so that because Home Affairs is made a party here.
yes,
That's why we are specifically
Yes.
issuing an order that they will communicate with them.
yes. my
So
lord.
who is the authority? External Affairs or
I think, my lord,
MHA?
it will be, I think, my lord, MHA, my lord.
So Ministry of Home Affairs is a party here
Yes, yes,
with the Ministry of Home Affairs and or any other authority
Well.
who would be competent to take up the matter with the Embassy of Nigeria, Embassy of Federal Republic of Nigeria. Next para. List on, give a date after 7 days.
but can it be after, my lord, 10 days, my lord, basically after 2 weeks, my lord? Any date after 2 weeks?
Because once he is alleging illegal detention,
But one thing, may I point out one thing, my lord?
Hmm.
Here in para 8 of the writ petition, my lord, the petitioner is saying, my lord, the case was initiated not against him, against somebody else's name. my lord.
no, he's giving two names.
Yes,
He was traveling with
Yes.
one so and so.
yes,
All the
Right.
proceedings took place in the name of so and so instead
Yes.
of his real name of the petitioner, that
Yes.
is Kamaruddin Odolji so and so.
Even
That is
my-
what he's proceeding.
yes, so may kindly come to the order now, my lord, page 20, my lord.
20.
The accused person is Jaka, Akane.
Yeah, so now let's may kindly, yes.
Yes,
So when it's, may I assist you?
Yes.
May I kindly come to page 29? No, when I came to from Bangladesh, entered Karimganj, I have a passport of my friends. That is Jack Oladipapo Akane. And based on that, I was convicted. Now, and I communicate, again and again communicate that my name is, original name is my original name is Kamardin Oladiji, or then I am a Nigerian citizen, but no one listens to me, my lords. My lords, may kindly come to page 29. That is a representation that I have written to the Ministry of Home Affairs. And anyway, I have been convicted. So the sentence is the same only as in the passport side. That is a non-issue.
Okay, yeah, just make a mention. Extra copy is the writ petition along with the scanned copy of the writ petition to the London CCC.
my lord.
Give a scanned copy, otherwise he'll be finding it difficult to get it
Yes,
scanned and send it. But that should not be a problem for the ministry because he's there in the jail, in the transit camp. His photograph can be compared and it can be seen.
my lord.
Uh, Just make the notice instead of 1 week, make it returnable on 9/5, then you are getting more than 2 weeks.
My lord,
9/5/2025.
my lord.
Give a scanned copy also along with copies.
All right. Here you go.
Item 6 for admission.
I have lost.
Right, Lordship. So Lordship here in this case, Lordship, the lack of link in between father and the daughter, Lordship. The daughter is a petitioner, Lordship. So whatever here in this case, Lordship, the opinion clear defined, Lordship, exhibit number 1, Lordship, which is clear defined, is a page number, Lordship, 59, Lordship. The internal page of the opinion, Lordship. Can find, Lordship. Page 59.
Page number
Page 59, Lordship.
59.
It's opinion, Lordship. Internal page of the Lordship.
Yes.
Lordship, the exhibit number 1, which is clearly defined, the petitioner father name is the Muslim Uddin, Lordship. And the grandfather is a Akhidil Sheikh, Lordship. So the learned tribunal set out, Lordship, the Akhidul is the father of the petitioner, Lordship. So here exhibit number 1 is clearly defined, Lordship. The Muslim Uddin is the father of the petitioner, Lordship. And I have appended the annexer 1, Lordship, page number 20, Lordship. And you find, Lordship, page number 20, Lordship.
Page number
20, Lordship.
20.
Yes, Lordship, 20, Lordship. It's a type copy, Lordship.
Yes.
It's a voter list of the 1966, Lordship.
Yes.
It's a Muslim Uddin. Muslim Uddin is the father of the petitioner, Lordship.
Yes.
It's clearly defined, Lordship. And the original copy is, Lordship, the page number 21, Lordship.
Yes.
Muslim Uddin is my father, Lordship.
Yes.
But the learned tribunal says, Lordship, the Akhidil Sheikh is the father of the petitioner, Lordship.
Where is that?
So the page number 59, Lordship, is a internal page of the judgment, Lordship. So that part said Akhidil Sheikh, Lordship. And also, Lordship, the page number 58 also, Lordship. Lordship, I look at set out, Lordship, and the aspect, Lordship, the school certificate, Lordship, school certificate is a page 32, Lordship.
we did not get it. In page 59, you are saying that the name of the father is wrongly recorded. Which paragraph you are
Yes,
referring
yes,
to?
Lordship, I'm sorry for that. There are another paragraph mentioned, Lordship, page number 63. Is
60?
63, Lordship. Internal page of the judgment, Lordship. Opinion.
63.
On careful scrutiny, Lordship. On careful scrutiny, Lordship. 63, Lordship, please. Is the second paragraph, Lordship, bottom. On careful scrutiny, Lordship.
Yes, please read it. Where he has wrongly written the name of the father.
So careful scrutiny of these documents, it is seen that if the proceeding above exhibit number 5 and the exhibit number 7 are the excluded, the considering there is no any linkage proceeding and her projected father. Therefore, the proceeding able to prove her linkage, then there is a needed to discuss the citizenship state of the projected father, Muslim Uddin Lordship. So here, Lordship, the Muslim Uddin is a exhibit number 1 is clearly defined, Lordship. Muslim Uddin is not father of the petitioner, Lordship. Failed to do the, therefore, there is no need to discuss the citizen status of projected father of the proceeding is formed. Other
So
exhibited.
what is wrong in the writing of Muslim Uddin? Is it wrong?
No, Lord.
Then you are saying that the name is wrongly written. Please show us that entry. Your case is that the tribunal recorded your father's name wrongly. Show us that part.
I like to set out, Lordship, the
No, don't read here. You must read the brief at your home.
so here, Lordship, the tribunal says, Lordship, the father of the Muslim Uddin, but proceeding failed to there is no need to discuss the citizen status of the proceeding projected father.
Correct.
Lordship, here, Lordship, the petitioner father name is the Muslim Uddin. This is correct, Lordship. Exhibit number 1 is clearly defined, Lordship. It's a page number 20, Lordship.
No, you see, it's a simple case where A says that B is my father. A and B are not connected. So issue of deciding the status of the father is immaterial. Why should the tribunal go to father first? First, he will. The court is rightly done. This tribunal is rightly done. Is connecting the first, examining the documents of the son. Proceedee.
Yes, Lordship.
Proceedee does not link himself with B, who is the father. So why would tribunal examine B?
And Lordship, the exhibit number 1, Lordship, which is clearly defined, Lordship. Exhibit number 1, I have already placed, Lordship. So the
Exhibit 1 is a voter list.
voter list, Lordship.
Voter list, tomorrow the proceedee may bring your voter list. It is available in the
Father
website.
list, Lordship.
No, I understand.
And
But
Lordship,
voters list is something which is available in the public domain. What happens if a proceedee brings your voter list tomorrow?
Lordship, I have the another documents, Lordship, the page number 32, Lordship, is a school certificate, Lordship. That's the clearly defined, Lordship. Page number 32 is a type copy, Lordship. Annexure 7, Lordship.
School certificate was not produced before the tribunal. In fact, in your evidence before the tribunal, which we were reading, you have not even mentioned the name of your father. You just say that voter list contains the name of my father and grandfather. Who is the father? Who is the grandfather? You don't have you don't say anything.
Lordship, the school certificate issued by the Lordship, Gaubura, Lordship, and the Gaubura is clearly defined, Lordship. It's a transport certificate, Lordship. Kindly find it just for a moment, Lordship. Page number 32, Lordship.
Page number?
32, Lordship. The annexure 7, Lordship. Is a type copy, Lordship.
Which is this exhibit number?
7, Lordship. Not proof. Yes, Lordship, page number 60, Lordship. Exhibit number 7, her school certificate, Lordship. Page 60, Lordship.
Evidence কেতিয়া দিছিল?
Did you examine the headmaster of the school?
No lordship.
Then how does this document help you in the first line of the document at page 34? First word written here is duplicate.
The Gabura, the Supreme Court held lordship one of the judgment is a Ansela case lordship. The Gabura certificate is a valid document lordship. That's the possible. Okay.
Gabura certificate. Where is that?
Panchayat certificate lordship. I'm sorry for lordship. The
Panchayat certificate. Yes. How does it help you?
Lordship, the Panchayat certificate. So lordship, the migration certificate page number 35 lordship. Gabura is page 35 lordship.
35.
Yes, lordship. Type 50 lordship. And the original page is page 37 lordship.
37. You are reading 37.
37. Yes, lordship.
Yes.
So here the petitioner is a Moriam Nessa lordship, the father of Muslim Uddin lordship, and issued by the is a secretary Dhupaguri Gao Panchayat lordship. Dhupaguri Nogao Assam so issued dated 36/2015 lordship. The Governor of Assam Office of the Secretary Dhupaguri Gao Panchayat lordship. Dhupaguri Nogao Assam this document says reflecting as the exhibit number 5 lordship.
Was this Gram Panchayat secretary examined?
No lordship. Did not come examine. The Chandan Kumar Nath, Secretary, Dhupaguri GP, Gao Panchayat. So contact number. The petitioner aged about lordship the 50 years lordship. So lordship, I may allow to lordship opportunity to establish the burden of proof for the tribunal lordship. Another opportunity lordship. And Lordship, I like to say some of the another aspect, Lordship, and the land documents is a Zuma Bondi, we also appended Lordship as the annex 9, is 38 Lordship.
Page?
Page Lordship, 38 Lordship, the type of Lordship, serial number 19 Lordship. And original is Lordship, original is Lordship, original page 40 Lordship, serial number 19 Lordship, Moriam Nessa Lordship.
This entry is made in 2007.
Yes, Lordship, 2007, but the land record Lordship. In linkage documents Lordship. And Chokro because 2002, the Imam Dagot Muslim Uddinor Stanot, Moinul Haq, Anul Haq, Moriam Nessas, case number 39, which is circle officer recorded Lordship. Muslim Namot Namzari Hoy.
You have a copy of this mutation order? It is mutated on what ground? Is it inheritance? Because
Indian is lost.
where is
not
it written?
valid.
It's not written here.
Yes.
In page 39, inheritance is not written. That's why we are asking you. You have a copy of the mutation order? So somewhere I read
Yes, yes, Lordship.
in the evidence you said that your father died 15 years ago. If it was 15 years ago,
Because of the Imam Tiger Muslim Uddinor Stanot. Muslim Uddinor Stanot, that is Lordship is a in the Stanot, that is an inheritance Lordship. Stanot. The circle officer is a wrongly recorded Lordship, but documents are the genuine Lordship. Muslim Uddinor Stanot, Moinul Haq, Ainul Haq, Moriam Nessa. Azuba Afia Khatunor Pitri Muslim Ali Namot Namzari Hoy. Reflecting page 39%.
where is your written statement?
Lordship, page number, Lordship, 51, Lordship, annexer 13, Lordship. Yes, 51. Lordship is the type copy, Lordship, page 51, original is Lordship, start.
And where is your affidavit? Evidence on affidavit?
Lordship, verification is given, Lordship, page number 55, Lordship.
45,
55, Lordship,
55.
the bottom portion, Lordship. We have a song there.
No, your evidence on affidavit. How did you give your evidence?
Yes, Lordship, page 45, Lordship, annexer 11, Lordship. Okay, okay, I'm sorry, Lordship.
It's okay.
It's taken on
43.
43,
It's
yes,
okay.
yes. Yes, yes. Deposition on part petition, yes. Page 43, Lordship.
Take a short break and come back.
Yes.
Yes, Mr. Sharma.
Lordship. There is
Mr.
no,
Das, you have anything more to say?
No,
Mr. Sharma?
there is no infirmity in the opinion, Lordship. I had perused the opinion,
Mr. Das
Lordship.
says that the sale deed and etc. are not considered.
Yes, court, Lordship considered, Lordship. Here, para 62, Lordship. What they have exhibited, Lordship, all the exhibited documents are considered, Lordship. But Lordship, one aspect is there, Lordship. This school certificate, Lordship, page 34, 22 to 2020, Lordship, date of issue, but below signature is of 2021.
Which page?
Page 34, Lordship. Initially, the proceeding has given evidence, Lordship, in the year of 2016, Lordship. Page 46,
40,
46.
forty-three,
46, Lordship.
46.
Lordship. Here regarding land document or in 40 evidences I have perused, Lordship. Nothing has been said, Lordship, regarding land document or school certificate, Lordship. And after giving evidence, Lordship, this document, he has brought this document before the tribunal, Lordship. And Lordship, headmaster never come to depose before the tribunal, Lordship. This is more important aspect, Lordship.
Just a moment.
After page 46, Lordship, he again deposed before the tribunal, Lordship.
No,
Page
that is because of
43.
the fact that this order was set aside by the High Court. And the
Lord-
matter was,
Yes,
uh,
yes.
the case was registered again.
Oh, Lordship, yes.
Here, uh, the opinion of the tribunal was passed on 8/17 without any reasoning. This opinion merely says proceeding is present after considering materials on record. Proceeding name is so and so is declared not to be a foreigner.
Yes.
That is the opinion. After this, the High Court, by order dated 22/6/18, passed some order, I don't know what. And then this case was re-registered as on 4/3/2020.
Yes, Lordship.
That is what has happened here.
Okay. Lordship. Then Lordship, after remanded, those documents are procured by the
Yes,
proceeding, Lordship.
yes.
And most important aspect is that, Lordship, headmaster never come before the tribunal to prove this document, Lordship. And similarly, Lordship, Gaon Panchat certificate, Lordship, also Gaon Panchat secretary never examined, Lordship, for the tribunal, Lordship. And apart from that, document itself is not admissible in evidence, Lordship.
Yes.
Yes, Lordship. Regarding that school certificate and Gao Panchat certificate, Lordship, I want to rely on a decision of this honorable court, Lordship.
Yes.
WBC 7756 of 2016.
7,
56
of
2016.
15,
7756 of 2016. 16.
16. Yes.
Kudeja Khatun, KHUDJKHATWON. Para 12 is regarding school certificate, and Lordship, Para 14 is regarding Gao Panchat certificate. May I read, Lordship?
Yes.
Para 12, I am reading first, Lordship. Exhibit A is a transfer certificate dated 9/1/2016 issued by the headmaster of Uttar Durabandhi Bill LP School certifying that Masamat Khudeja Khatun was the daughter of late Jonna Bali of Durabandhi Bill village under Moirabari police station in the district of Morigao. She had left the school on 31/12/1988 after passing class 2. As per admission register, her date of birth was 12/1/1981. This certificate cannot be accepted as a valid piece of evidence for more than one reason, Lordship. Regarding first parties regarding state emblem, Lordship. Here I am not arguing regarding state emblem. And Lordship, second part is Lordship. Second part I am reading. Secondly, as per this certificate, petitioner had left the school on 31/12/1988. This certificate was issued 28 years thereafter on 9/1/2016. Such belated issuance would necessarily cast serious aspersion on the bona fides of such certificate, which is highlighted by the unauthorized use of state emblem of India, that too not as per the statutory format. Thirdly, and most importantly, the author of the said certificate did not appear before the tribunal along with school admission register to prove the contents of the said certificate, more particularly date of birth and relation with Junabali. How the date of birth in school certificate has to be proved has been settled by Supreme Court long back in Biratmal Singhvi versus Anand Purohit, reported in 1988, Supply SCC 604, and further reiteration is not necessary. Therefore, Exhibit A, besides not being proved, is also not admissible in evidence. Then, Lordship, Exhibit Para 14, I am coming, Lordship. Exhibit C is a certificate dated 13/2/2015. Lordship, Para 15, I am relying. Exhibit D is a certificate dated 15/6/2015 issued by the Secretary Goraibari Gao Panchayat certifying that Khudeja Khatun was the daughter of Jonna Bali. At the top of the certificate, Government of Assam was prominently printed. It was also mentioned in the certificate that same was issued on the basis of evidence placed before the Secretary. Firstly, this document does not appear to be genuine document in as much as a Gao Panchayat is not a department of Government of Assam. Therefore, Gao Panchat is not authorized to use letterhead with Government of Assam printed therein. Secondly, the Secretary of Gao Panchat did not testify before the tribunal along with the evidence on the basis of Exhibit D. Certificate was issued to prove the certificate as well as contents thereof. Therefore, this certificate was not proved. Thirdly, Supreme Court has clarified in Rupajan Begum versus Union of India, reported in 2018 1 SCC 579. That such certificate of Gao Panchat Secretary is by no means of proof of citizenship. Such a certificate has to be verified at two stages. At the first stage, authenticity of the certificate itself is required to be verified to find out as to whether it is genuine or not. The second stage of verification relates to verification of the contents. There is nothing on record to show that Exhibit D had undergone any such verification exercise. Therefore, Exhibit D cannot be accepted as a valid piece of evidence, Lordship. From if Lordship school certificate and Gao Panchat certificate gone, Lordship, then there is nothing to in this petition to prove his citizenship, Lordship. So this is my humble submission, Lordship.
So lordship, we do respect lordship. So here lordship, the deposition ought to be required lordship, the circle officer, land documents. So if the deposition ought to be required lordship, so kindly direct to the matter refer to the tribunal lordship, depose the circle officer and the secretary of the Panchayat lordship. They require lordship. So the petitioner approached several times lordship. So they refused to appear before the tribunal lordship.
Please repeat again what you have said.
So lordship,
Please.
kindly refer this matter before the tribunal lordship to establish burden of proof lordship regarding lordship circle officer and the secretary of the Panchayat lordship in depose in this regard lordship. As a burden of proof lordship.
We'll consider that.
Yes, lordship.
And another submission is that lordship regarding Jamabondi lordship, a petitioner said that lordship, it is not considered lordship. But here lordship, in page 62, last paragraph, Jamabondi is considered lordship as a exhibit 4. Lordship, in this Jamabondi, how the father of the proceeding name mutated, that was not mentioned, lordship, as lordship pointed out.
So that's why your deposition of the recall. Thank you.
Okay.
Oh. Oh.
Mr. R.C. Das, learned counsel for the petitioner, as well as Mr. All the names? M. Kalita on behalf of Ms. P. Barwa. Okay. Okay. So arguments are concluded, judgment reserved.
Much of it.
Yes, item 7.
My lord, on the last occasion, my lordship asked me to obtain an inspection regarding the date of arrest.
On 20/12/2024, petitioner was arrested. Lordship.
Please repeat again. I did not get it.
20 December 2024.
Okay. 20
December
December.
2024.
Will we release him on bail then? And Mr. Sharma, this was an ex parte opinion. Should we, have you seen the record? Can we remand it back to the tribunal to give an opportunity?
Lordship. Notice of one. My lord may demand it, but some cost may be imposed, lordship.
Service was
Otherwise,
completed.
notice was properly served, lordship,
Notice was
Yes.
served.
without considering on merit, lordship.
Mr. Mr. Aman, even if we want to help you, you place us in such a difficult position. The affidavit is sworn by the son.
Yes, madam.
Your statement that you gave the documents to your husband is at paragraph 2. Paragraph 2, as per affidavit at paragraph 12, where page 12, is sworn as matter of record.
And it should have been stated.
Now you see the paradox. We want to remand the matter back. The standing counsel for the FT matters is ready to. He says that some cost be given and it can be remanded back. But then you make a presentation where it's a hearsay statement. In this case, what is the best document you have to show your existence from 25/3/71? What is the best document? You or your parents? Where is that document?
Lordship, grandfather's name is in the voters list of 1966, Lordship. At page
And
20.
what is the document to link you with your grandfather?
No, with father, Lordship.
Your father, okay. What is
Grandfather
the,
and then father, Lordship. Father's voters list are there. And then one school certificate is there, Lordship, transfer certificate. At page 19, Lordship. Where she is shown to be the daughter of Hazrat Ali, Lordship. This was issued in the year 1988. Lordship. Sorry. This is the grandfather is there, 70. And then father's voter list also have an Lordship. Hazrat Ali and mother. Safan. Her marriage, Lordship, her name was also recorded in the voter list along with their husband, Lordship.
Mr. Sharma, we are remanding the matter back to the tribunal with the, on appearance, the tribunal will consider the prayer for bail. After all the conditions are fulfilled. But Mr. M. Ahmed and counsel for the petitioner. Also heard so for the respondents. Next para. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the ex parte opinion dated 30 May 2025, passed by the learned member, Foreigners Tribunal, Bajali, in FT case number so page 13, passed by so reference number by which she was declared to be a foreigner who has illegally entered into the territory of India within Assam from the specified territory after 25/3/1971 without any valid document. The learned counsel for the petitioner has submitted that though the notice of the proceedings was duly served on the petitioner on 12/5/2023, she had handed over the notice and photocopies of all the documents to her husband, who is projected to be residing at Harupitia with his second wife. However, he did not take any steps. And thereafter, the petitioner came to know that the proceeding was decided ex parte by an opinion dated 30/5/2023. Next para, the learned counsel for the petitioner has submitted that the petitioner has sufficient documents to show that she is not a foreigner. Accordingly, is that the matter be remanded back to the learned tribunal to give an opportunity of hearing to the petitioner. Next para, it is also submitted that the petitioner was not instructed about the date of that he was not instructed by the petitioner about the date of his arrest. In this regard, the learned standing counsel for the active matters has submitted that as per instructions received, the petitioner was taken into custody on 20/12/2024. And it has taken a lot of effort for the border police and the district administration to apprehend the petitioner. The learned standing counsel for the FT matters has also submitted that none of the documents which are disclosed by the petitioners can establish her link with her projected parents. So moreover, comment is submitted that as the notice of the proceedings were duly served to the petitioner, or the ex parte opinion ought not to be interfered with, as the petitioner took a calculated risk of not proving that she's not a foreigner, for which burden lies on the petitioner under Section 9 of the Foreigners Act 1946. Okay. Next one. We find force with the submissions made by the London Standing Council for the FT matters that as that notice was duly served on the petitioner. And therefore, the petitioner has taken a calculated risk of not appearing before the tribunal on the date fixed. We find it very difficult. Certain things come to our notice, and then you see, you project that your husband is, you are a resident of district Borpeta, correct?
Yes.
And your husband resides with another woman at
Kharupetia.
Kharupetia. You went to Kharupetia to meet your husband, gave all the documents, and the affidavit sworn is by your son, who's 25 years old, and he signs in English.
Yes.
Why you did not rely on your son? There are two sons, two children, you say. Why you can't rely on your son?
As per the instruction, Lordship, they
Oh, we
were
understand, but
out of
you
station
went,
at
you
that
see, you are projecting a case. It must strike confidence of the court. Even if you want to give halfway the dictation, now we look at this affidavit is sworn in English. He signs in English. That means he's educated. This signature does not appear to be a person who is not educated. You take a plea of going to your husband and then you can't, your son is well equipped, he files an affidavit before this court. Although we don't pass a comment that the mother is arrested and son does not know the date of arrest, for which we had to adjourn the matter on the last occasion to get the date of arrest. But if that be so, then we are bound by our own judgment, where it says that the ex parte opinion should not be lightly interfered with. You must file a better particular. This is something which you can't accept. Halfway the dictation, we find that it just can't stand. This is not a signature of an uneducated person. He has been, he has received some education. Does not appear, is not, you just look at the signature, Dasji.
So at that time, Lordship, he was out of station or like.
No,
that,
no,
but-
whatever, but you see, when we are interfering with an opinion,
Yes.
and we are passing an order contrary to our own earlier judgments, which says that it should not be lightly interfered with. Look at the signature. It's not of an uneducated
Yes.
person. Because you see, our orders are subject to question even by the state. The state would say that why I did not follow the precedent. So you must make out a case where the, despite the precedent, we take an exceptional view, and that is missing.
Imposing some cost, Lordship. Like, there are-
No, no,
yeah, Lordship.
cost is not a substitute.
Because
Cost
in-
does not validate an invalid order. I must give a finding. Because there are precedents. He can cite 3 at least.
Because she is already in custody, Lordship.
No, no.
If
Question
she
of
from the
custody.
Custody, let her prove her case, Lordship.
No, no, custody is okay, but you see, we are trying to allow this application. Even tomorrow, even if we grant bail and hear the matter tomorrow, still it will be the same question. On merit, we don't find anything. If on merit we don't find anything, the question of bail will never come. We are giving you this record, if this, the story must match. It's not. I find it very difficult. You file a better particular. This is something which you can't accept. Let's change the order, say that the. So then we take up the matter for hearing tomorrow.
Yes.
We give you an opportunity of a day to show us this order, let it remain for the time being. Just we pass a new order. Keep this with you. All sides are represented. Pursuant to the last order, the understanding also for the FT matters is submitted that the petitioner was taken into custody on 20/12/2024. Next, whereas the records are received, court is inclined to hear the matter out of turn, considering that the petitioner is in custody since 2012/2024. Next, list on, make it tomorrow, 29/4/2025.
Lordship, in the second half, Lordship.
Huh?
In the second half, Lordship.
Okay, just ask somebody to make a mention, or Mr. Sharma, please remind us, we'll take it up next time. Well, I may say yes to you now, but I may forget after some time. Very likelihood that I would forget. Please remind me tomorrow morning. I'm just addressing the bar. Today we have single bench also with criminal matters. So second half, we may not take up this, division bench may not be extended in the second half. We'll have to take up bail matters and criminal roster. Yes, you want to say something?
My item number was 10, my lord. But
Yeah.
the petitioner is in custody, my lord.
Pardon me?
Item number 10, my lord.
Yes.
Petitioner is in custody from 2012 to 2024, my lord. The matter will be listed.
Okay, day after tomorrow. In those matters where the people are under custody, please tell the name to the court master. We'll fix it within this week. Any other matter, if it is there, people are in custody, please tell the court master.
My item 15 loss. That's in custody loss.
Just tell the court master. We'll fix it within this week. Just tell the court master after we rise.
Regarding item number 11, my lord, it's a matter of the education department, my lord.
Hmm?
It's a issue with regard to the SCRT education department, my lord. This case is supposed to come in the motion,
We don't get it. It relates to which department?
education department.
Education department. Okay.
Come for motion, my lord. Notice has not been issued in this case.
Which item?
Item 11, my lord.
11.
Yes.
Okay, please give that. 11. Item 11. Who is appearing for the education department?
SCRT and NCTE. Elementary education department and the NCTE I alum, my lord.
Huh?
NCTE I alum and SCRT is the elementary education department. Rule is put to challenge, my lord, therefore it is registered to the division bench 1, but due to technical difficulty, the division bench 1
Okay.
could not take it up.
Just give a scroll for SC elementary education and SC NCTE. Eight. Huh? Huh?
We have put to challenge this, my lord, diet rule, page number 68, your lordship, earlier occasions dismissed one writ petition. Made an observation in page number 68, paragraph 27.
Page
68,
68.
paragraph 27. As because the rule, diet service rule 2010 was not under challenge in that round of writ petition, my lord, the honorable court could not take up the issue while adjudicating whether the PhD degree would be essential for promotion to the post of principal diet in respect of elementation, in respect of this rule.
But then should I take it up?
As your lordship, because this is in the division bench 1, it was also not taken up because the Honorable Justice Ibn was the one of the counsel in this connected writ petition. That's why it was not taken up. And therefore it is listed before your lordship. Your lordship,
I think I should not take it up then.
yeah, then it will go to my special bench, special division bench.
Okay. Mhm. Mhm.
They didn't.
The petitioner herein had earlier filed WPC 4963 of 2023, challenging the selection to the vacant posts of principals of diets DIET small s in the state of Assam on the ground that the senior lecturers whose names were recommended did not have PhD degree and M master of education M full stop ed ed degree, which is the requirement under the guidelines of the NCTE. Full stop. By a common judgment passed in the said writ petition, which was heard along with other matters, the said writ petition was dismissed by one of us, in bracket, K.R. Surana J, by judgment and order dated
29/8
what was the date?
29/8/2024.
29/8/2024. Full stop. Next para accordingly, the petitioner has filed this writ petition praying for modification and or amendment of the Assam District Institute of Education and Training within bracket DIET bracket close service rules, 2010 for incorporation of PhD degree as an essential qualification for the post of principal, diet. Next para, as a similar issue, raised by the petitioner has been decided by one of us, let this matter be listed before any other bench without one of us within bracket K.R. Surana J. In this case, what had happened, I was thinking that I should recuse myself from the matter. But now I find that the issue raised was decided by this, by me sending singly. The matter, it now appears that went in writ appeal. Writ appeal 336 of 2024. The writ appeal was dismissed. And the division bench passed an order that the writ petitioner is free, appellant or writ petitioner is free to make a separate challenge to the validity of the rules. Now that rules have come into challenge, I don't think then this would be a bar, because division bench has already passed an order. So that order has attained finality, and now the challenge is the petitioner is permitted to make challenge to the rules.
No bar.
It should be no bar. Okay, don't pass that order. We issue a notice then. Okay. But Mr. B. requested on counsel for the petitioner. Next, by filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed has prayed for a direction for quashing and or modifying and or amending the Assam District Institute of Education and Training within bracket DIET bracket for service rules, 2010 for incorporation of PhD degree as an essential qualification for the post of principal, diet. Next para. Then this earlier paragraph will come. Earlier paragraph will come now. Yeah. Then say after this paragraph, we say the petitioner preferred an appeal being WA 336 of 2024, and the division bench of this court, by an order dated 2012-2024, dismissed the appeal. However, the petitioner was given liberty to make a separate challenge to the validity of the rules of 2010, if advised. So, full stop. Next para. In light of the said order, the court is inclined to issue notice of motion returnable on education has come. No.
I will inform them.
Return
I will
within
inform.
4 weeks. Most of requisite extra copies of the writ petition we served on the learned.
I allow my lord only for respondent number 2, my lord. And for respondent number 1, it is the
Just a moment. The school education within bracket elementary education bracket close department council, and to the standing council for NCTE within 2 days. Next para. List after 4 weeks. Just inform them that this order has been passed today.
Yeah, please.
Okay. Yes.
I take your notes, please, that just to mention one thing. Not, I have item number 14. I want to update it, my lord.
Okay, we'll take it up. Item 14.
14, yes.
Okay, we'll take it up. Right now, we'll take it up. After the mentions are over.
Whether your lordship will take it now or whether they have other to mention, I do not know. I'm mentioning.
Yes. Next.
Item number 8, Malad, of today's list, Malad, the admission matter. Malad, the case diary has not yet come. It was called for earlier also. And the informant council is also appearing.
I prefer short that, my lord. I will put it.
How many- How much? When? Suggest a date.
মিছামাৰী my lord. শোণিতপুৰ আপুনি কেতিয়া থাকিব?
Yes.
30, yes, they are continuing 30 my lord, 30 May.
30th of May.
They are-
30 May.
yes,
It's
they
a
are
long
both-
time.
I'm led by Mr. Singh in this matter. So, and in fact, Malad, earlier also the case diary was called for on 3 occasions. Some seriousness should be.
Uh, Mr. A. Ganguly, learned counsel for the petitioner submits that on earlier 3 occasions, the case diary was called for, but the same is not produced. Uh, Mr. B. Sharma, learned APP, prays for some time to produce the case diary. Case diaries of which police
my lord,
station?
that is my lord, মিছামাৰী PS case number 76 of 22,
Okay. Next, para.
2020.
Accordingly, the officer in charge of Misamari Police Station is directed to ensure that the IO of Misamari PS case number
My lord, 76 of the 2020-22, 2020.
shall ensure that the case diary is handed over to the office of the learned public prosecutor, Assam before this of this court on or before 28/5/2024.
Right.
Next, para, the learned AVP shall send a message to the said police station through the VHF facility installed in the court. Next, para, list on 30/5/2025. Send a message.
My lord, my lord,
Yes.
my lord.
Deeply read.
May I please, your lordship? On the consent of the other side, lordship, I beg to mention item number 19, lordship. Matter may be pass over for the lordship.
Okay. Your name?
M. Hussain on behalf of R. Ali.
Mr. M. Hussain, learned counsel, appearing on behalf of Mr. R. Ali, learned counsel for the petitioner, submits that he has taken consent from the other side and prays for adjournment. Prayer is allowed. Let the matter be passed over for the day.
Deeply.
May it please your lordship. I beg to mention item number 9, your lordship.
9, okay, yes, adjournment slip was given.
Yes, sir.
Okay,
Interim to continue, lordship.
Okay.
Can it be on 8th or 9th of May, your lordship? Senior counsel Mr. Bhaskarath will be appearing in this matter. He comes from Tinsukia.
list on 9/5/2025 as prayed for by learned counsel for the petitioner.
Deeply obliged, your lordship.
With due respect, my lord, I beg to mention item 5 as my senior counsel was out of station.
5,
Item 5.
okay,
ALE,
on the prayer made by Mr.
A. Sharma on behalf of ALE.
A. Sharma on behalf of Mr. A. Ali, learned counsel for the petitioner. Prays for adjournment, prayer is allowed. List when?
After 7 May,
Okay. List on 9/5/2025.
Lordship, item 13, Lordship, I have checked the office note. The service is awaited, Lordship. I have checked the
Item 13
Lordship.
on respondent number, sole respondent.
Respondents.
Okay. After 2 weeks then,
Lordship.
okay. Mr. D. Das, learned counsel for the petitioner, submits that as per office note, the service on respondent is awaited. Stop. Let the matter be listed after 2 weeks along with the report of service by the registry.
I'm okay.
Yeah, please, Your Lordship, in respect to item number 6, Your Lordship. Your Lordship, learned counsel M.K. Sharma is out of station, Your Lordship. Kindly please submit after sir. Next week.
Okay.
Item number 6.
6. You want after how many days?
Next week, Your Lordship. Let the matter may come next week, Your Lordship.
List after a week as prayed for by Mr.
S.K. Kashyap on behalf of M.K. Sharma.
S.K.
Kashyap.
Kashyap, learned counsel appearing on behalf of Mr. M.K. Sharma, learned counsel for the petitioner. Okay.
Give them.
Item 1,
Oh,
upgraded item 14.
This case, Your Lordship,
you'll have
Yeah.
to take first steps because service is still not completed. You'll have to take it through the regular process. The service is not yet complete. You'll have to
it
take
is
first steps.
complete, but it is only 2 months has elapsed.
No,
And
you'll
because
have to take first steps through usual process.
then Your Lordship has to, this is the last, next date will be fixed then, Your Lordship, for return of the, and in the
for return.
meantime, whether Your Lordship can allow me to have the any time stay, because you had to pay the money. It is.
This
Okay,
is a
so-
matrimonial dispute. This is matrimonial dispute.
That is true, Your Lordship. But what happens, my lord, in this case, well, it cannot be that. We are praying for invoking the inherent jurisdiction of this.
But the maintenance is 3,000 rupees. Maintenance allowed is only 3,000 rupees.
That is true, my lord, but it is not justified, my lord, under no circumstances. That is.
How
my
much is
lord.
your earning?
Because what happens, my lord?
No, how much is your earning? Your own earning is how much as per the affidavit?
Not regular income. That is not the thing, Your Lordship, because it is not, it cannot be granted.
No, we understand.
Because already, yes.
Mrs. Deka, 3,000 is too much. We understand. 3,000 nobody can pay. That also we know.
My lord. That
But
is
the
true,
fact is that how much you earn, you are required in a matrimonial dispute to say on affidavit how much your earning is. What have you disclosed your earning?
There is, my lord, that actually. that
Otherwise, what
cannot
we'll
be
do,
granted, that cannot be
Mrs. Deka,
granted, my
I
lord.
have an answer. What you will do is,
He has not regular income, my
no,
lord.
we understand,
Eh.
but whatever income you generate will not be paid to you, it will be paid to your wife. And the very high amount of 3,000 rupees, she will give it to you.
That is not the thing, my lord. What happens? Because already,
No, you
my
see,
lord,
3,000 is too much.
no, it is
3,000 is too much, exorbitant.
127, my lord. 127, my lord. It is,
Mrs. Deka, it is 3,000 rupees only. If you don't earn 3,000 rupees,
no, my lord, that cannot be granted because already wife
then
has
you
taken
suffer.
the money.
Then
And
there is another way out.
File,
If you are behind the bars and work, then I think the police administration gives you payment. You will earn 3,000 rupees to pay to your wife.
no, she is not, 2,000 already she is received, my lord. 2,000
no.
rupees we have paid already.
You
That
see,
is
please,
regularly we pay.
please come to page 26. In paragraph 12,
Yes, yes.
On page 26, the court has presumed your income to be 15,000 to 20,000.
That is, my lord.
Please
No,
show that this is,
no, my lord. That is, my lord. It is stated by the witness that it is only speculation he has stated. Only speculation is stated, my lord.
we
And
understand.
not only that, my lord.
But please show that
under-
this is wrong. Please show us that this is wrong. Mrs. Deka, 3,000 rupees.
that is
How
too
can
much,
somebody
3,000
survive?
rupees.
If the person eats only potato for 1 month, the bill will come to more than rupees 3,000.
But my lord,
Not to speak of oil, not to speak of rice, not to speak of wheat, just
lord.
potato.
but how it can be granted, my lord? Because 2,000 he has paid, my lord. That we did not object to it. We paid it. But Payal, who is a daughter, she has said, he did not know, my lord. And another thing, my lord, she has filed all the false
And this
cases.
is a maintenance for your daughter.
No, she's not my daughter, my lord. That is also another thing. We paid for.
Did you
her
undergo paternity test?
also, that was also.
Did you
done.
offer for paternity test before the
Paternity
trial
test-
court?
Paternity test also did not they make.
Did you offer?
Yes, my lord.
We know of a politician in Uttar Pradesh. He contested a matter, and then after, when paternity test issue came, he admitted that the person was his son. I'm forgetful of names. I don't remember names. I can't remember names, but I remember the incident. I don't know. I something I can't. Few things I can't hear, and
No, that is definitely your.
it's hard of hearing of some things.
But
I don't know. I'm hard of hearing. There's some things I can't hear. It is,
Another thing,
Mr. Chidawat, I'm just like that man who takes loan. And after that, when man says, please return me 100 rupees, then I say, then this 100 rupees I can't hear.
When I hear this case is somewhat different.
No, we don't know, but let it be service because we can't state. You see, under section 112 of the Evidence Act, once it can be shown that the man had access to his wife or his what you call with this the lady, then presumption of a genuine bona fide not bona fide, it's called the presumption of a lawful child is already there. So you'll have to demonstrate from something which we don't get it here.
that is.
We'll see. Let it be served.
no,
Let the wife come.
It is quite different, your lordship.
Let the wife come.
Because what happened, no? First maintenance case was filed by the wife, my lord. Wife. But second case was filed by the daughter.
But your daughter, yes.
Daughter, who she did not know that the daughter was born to her. She left the matrimonial home long before.
That we don't know.
Yes, my lord. That is a
That we
different
don't
my
know.
lord.
Let the
And
wife come
no
and
division, we have stated all the things in the revision petition.
we
But that
have
was-
seen that, but we are not passing any orders without hearing the other side.
My lord,
You take steps. Let
yes, we have
it
not
be.
received the notice. That is a different thing. That is what we
Let
have
it be
but
served.
taken step immediately.
Let it be served.
Then, my lord,
Heard Mrs. K. Dakal and counsel for the petitioner, as well as Mr. B. Sharma and additional for the state. That's point
my
number
lord,
one.
whether it can be fixed on 29,
Okay.
29 May, my lord.
Okay. As per the office note dated 24/4/2025, neither ID card nor unserved notice has been received back. So accordingly, the petitioner shall take fresh steps for service of notice on the respondent number 2 by registered post with ED, as well as through usual process, to be served through the jurisdictional magistrate. As per the Guwahati High Court rules, with suitable correction to the form. Next para. The notice is made returnable on 29/5/2025. So list accordingly. Just
Must have been.
Item 1, motion BA.
It's a regular bail application under section 482 of the BNSS, my lord. Here, my lord, lordship was pleased to reject the bail, my lord, earlier occasion, my lord. That order, my lord, we have annexed, my lord. That lordship file page 153, my lord,
This is the trial is going on.
going on, my lord. Now,
Is the records available in that earlier case?
no, my lord, because earlier it was only one witnesses, my lord. Now it is four witnesses.
Okay, you have produced those.
Four I have produced, my lord, and only on last occasion, my lord, on 24th, the date was fixed. That day, what happened, I don't know, my lord.
Okay.
And
The earlier order is at page 148.
my lord, 153, my lord.
153.
My lord.
Okay. In this order, I would have referred that records are available where?
Records were possibly not called for, my lord.
No, it will always be there.
Possibly, my lord, I may be wrong, my lord, because my lord, one line I have, yes, my para 11, my lord, 156, my lord, page 156, para 11. My lord.
Yes, do we have to call for the records or it will not be required?
It's required, Lord.
For what purpose?
Reports the trial of the cases where the PWs have been examined or not, Lordship.
No, he has produced the copy of the deposition. He says that one is left out.
You may call for the last
Last
because others
orders
we have
of the
annexed, my lord.
Evidence, if any, recorded after
On 24th and such.
on 24th and thereafter.
thereafter, Lordship.
Okay. Mr. H. Chaudhary, and counsel for the petitioner, as well as Mr.
K. Jain on behalf of SCKL.
K. Jain, learned counsel appearing on behalf of Mr. SCKL, standing counsel for NCB. Next paragraph. The learned counsel for the petitioner has submitted that this matter is tied up with this bench as the previous bail application was rejected by this rejected by this bench. Next paragraph. It is submitted that the petitioner has annexed the copy of evidence of 4 witnesses which have been examined prior to 24/4/2025.
My lord.
So accordingly, it is submitted that the court may call for the scanned copy of the relevant records in respect of evidence which has been recorded on or after 24/4/2025. Next paragraph. Accordingly, the registry shall call for the scanned copy of evidence, if any, recorded on or after 24/4/2025 by the learned special judge within bracket NDPS. Correct?
DPS, Kamrup,
Kamrup, Aminggaon. Give it next week, I think by. Will it come by next week?
It will take some
Take
time
some
possibly.
time.
After 2 weeks.
Okay. Then make it list on 9/5/2024, it will be 2 weeks.
My lord, can I make an additional prayer, my lord?
Yes.
So, my lord, here, my lord, we tried to get the copy of the arrest memo and that intimation memo. We could not get it.
Achha, okay.
Can those be corrected?
Okay. Evidence if any, number one, let it make it number one. And number two, memo of arrest, public arrest challan of initial arrest of the petitioner in connection with
And civil crime, my lord.
and
24 of 22. And civil crime 24 of the 20.
NCV crime number 24/2022. For the next date, you also write, the learned standing counsel for the NCV shall also examine if they have record of the arrest memo of in respect of the petitioner and produce the same on the
My
next date
lord.
of this.
My lord, can I add 2 lines? I'm sorry, my lord, that arrest memo and notice under 50, my lord, NDPS, my lord. I'm sorry, notice 50, it is there on page 48. Can you have a look once?
Page?
48, my lord. That para 20, my lord, page 48. Para 20 and para 22, my lord. Those two things. my
Okay, now that's number two is arrest memo. Number three is notice under section 50 CRPC.
My lord.
Two items, last 2 items, the NCV. Well, examine if they have records of this and produce the same. Okay. Mr. Carol, normally when I deal with this bail applications, I call for the records. Is the earlier records available somewhere? No. You are aware of it? No.
No.
Okay. Item 2.
Much better.
May I please, your lordship?
You are sure you are holding a right brief?
That's good.
Yes.
Revision application, my lord, arising out of conviction under 138 NI Act.
Okay, achha, against conviction.
My
Okay,
lord.
I'll issue notice then.
Right.
But if it is an act, you'll have to make some deposit. That is, I think, the law. How much? What is the value of check and how much will deposit?
My lord, the value of check is, my lord, 2,75,000.
How much will deposit?
I can deposit, my lord, 50,000 at least, my lord.
50,000 too short. How much is required now?
20%.
20%. Okay, 50,000 then. Okay.
50,000, my lord, within 2 weeks, my lord.
Okay. Heard Mr. Arbor Pujari, learned counsel for the petitioner.
Impugn judgment and order dated, my
But
lord. 16/1.
is state required to be a party here?
Formal party. Formal party.
It's required. It's a complaint case arising or complaint. Why state is required?
My lord, but when we file, my lord, the revision applications, the system, my lord, as per the system, my lord, we have to, my lord, implement the state.
Okay.
Otherwise, my lord,
Okay.
registry do not register, my lord. That is the difficulty.
Okay.
They are only
Just-
formal party.
I will have a tendency to forget. Please write in a piece of paper and give it to the court master that the registry doesn't accept even in private complaint, so that on administrative side, I can make an inquiry. I'm telling you here orally, I'll forget. By the time I step down, I'll forget.
Definitely, right now, my lord.
You just give a small slip and give it to him so that I can administrative side, I can examine. Yes. And this is B Sharma, and then APP for the state respondent number 1. Next, right? By this application under section 438, read with section 442 of the BNSS, 2023, the petitioner, who is the accused,
in complaint case number
in
10 of
complaint case number 10/2023,
2014, my lord. 2014.
2013, see page 2, second line.
Yes, ma'am. Yes, well, complaint case number 10 of 2014.
13, page 2 is 13.
Yes.
In your cost title, page 2, I read 13. Is it wrong?
Well, it should be 10 of 2014. My typographical error, my lord. I seek apology for that.
It should be 14, okay.
If Lordship, maybe please to come to page 14, my lord.
No, it's okay, but I did not check it.
Page 14, it is.
10 of 2014. Don't write like this. You said by filing this one, so the petitioner has received the judgment and the judgment and sentence dated 27/6/2024, passed by the learned subdivisional
Subdivision and
judicial magistrate, Rangia, Kamrup, in complaint case number 10 of 2014,
my lord.
Thereby convicting the petitioner under section 138 of the NI Act and sentencing him to undergo simple imprisonment for 1 year and to pay a fine of rupees 5,22,500
My lord.
as compensation, which is inclusive of the check amount of rupees 2,75,000 and interest at the rate of 9% per annum, exempting the 2-year period for COVID, with default sentence. Post of the petitioner has also assailed the judgment and order dated 16/1/2025,
My lord.
passed by the learned additional sessions judge, Rangia, Kamrup, Rangia, in criminal appeal number 2 of 2024,
My lord.
by which the said conviction was upheld. So, which is that provision of that 20%? Where is that?
148.
148.
Yes, my lord. 148.
But then it will go to 1 lakh rupees, Mr. Barbujari, because this is
Compensation amount is
compensation amount.
5 lakhs.
Minimum of 20%. 148 says minimum of 20%.
That's
At
why
least
make it 1 lakh.
Any, my lord, any amount which lordship may deem fit and proper.
No, it's okay, because this is something which I don't regularly do. I tend to forget. Next, for the
But it gives me a, my lord, breathing period of, my lord, 60 days, 148(2). The amount referred to in subsection 1 shall be deposited within 60 days from the date of order. So lordship will kindly grant me 4 weeks time, my lord.
okay. Notice returnable on, give a date after 4 weeks. Check it out. Give a date after 4 weeks.
28/5.
28/5/2025. First of the petitioner shall take steps within 2 days for service of notice on the respondent number 2 by registered post with AD, as well as by usual process, comma, to be served through the jurisdictional magistrate. Comma, who shall return the service report of prior to the next date of listing. Next para, in view of the provisions of section 148 of the NI Act, comma, the court is inclined to suspend the enforcement of the sentence and fine, comma, as referred above, comma, subject to condition that within a period of 4 weeks from today, from the date of the order, comma, the petitioner shall deposit a sum rupees 1 lakh before the learned trial court, and proof of such deposit shall be produced before the court on the next date of listing. Just before that, also say, also call for the records
Yes.
of complaint case number 10 of 2014, and records of criminal appeal number 2 of 2024 from the concerned courts.
I'm so obliged.
Item 3,
Yes, Mr. Viswas.
My young brother, he wants to do first time in the High Court.
Oh, very good.
Please, your lordship.
Yes,
So this is the criminal revision petition referred against the judgment order dated 27/1/2025, passed by the Honorable Sessions Judge Bongaigaon in criminal case number 2 of 2019, wherein the learned appellate court was pleased to modify the sentence of 4 months passed by the learned court below, directing the child to be sent to a special home. The child in confined to a special home was reduced to 1 month. So
so you want more?
Because
Actually,
it used to 4 months to 1 month.
So from 1 month, you want for 4 months?
our prayer was to acquit him, and also the learned appellate court below did not consider extending the benefit of the Probation of Offenders Act or the benefit of probation upon the
No, but
child.
that can't, because you see, definitely what you did as per this judgment is to assault with a dao.
My lord.
Not sure.
Perhaps that is something which a juvenile will not do unless he has some other vices. Dao is something which a juvenile is not, will not normally have. What is the ground of your assailing this?
Your lordship,
Because notice on a revision may not be a matter of right. How do you?
lordship, firstly, the child in confinement has now become major of 23 years. So now sending him to a juvenile home again, your lordship, it would perhaps be against the interest of the other inmates also therein. And also, your lordship, no special, if your lordship produces the impugned judgment and order, no special reasons have been given, your lordship, as to why the concerned accused person should not be extended the benefit of the Probation of Offenders Act, your honor, your lordship. So this is one aspect of the matter also which needs consideration, and no special reasons has been given, your lordship. And in BNSS, your lordship, the requirement of special reasons has been provided. That in case if the court is not inclined to grant the benefit, then special reasons need to be given.
Where is the order of the JJB?
JJB order is on page 30, your lordship. Your Lordship, JJB is on page 17. The appellate judgment is on page 30.
You have your memo of appeal with you
Lordship.
before the appellate court. Is it available? Or you have a copy with you?
We have a copy, Your Lordship. Yes.
Because from the judgment of the JJB, it appears that you have been well trained by your father.
My lord, my lord.
How to use a thou, that that part of the education you received from your father. Because your father was present,
My lord.
you came along with your father with the thou and then assaulted the child just because of music in the picnic. We told you there must be something. This appeal shows that even these children of non-major children will having we were having drinks. But then this evaporates your ground of challenge in this appeal if it is only probation of offenders. You have seen this memo appeal. I have glanced very fast. I may have missed something, but I don't think that there's a ground of appeal has been set forth that Provision of Offenders Act was wrongly discarded by the trial court.
Even if the Lordship is the evidence of record.
No, because appellate court will have to be activated by your plea of the defense under Provision of Offenders Act, because that was the in the before the trial court, Provision of Offenders Act was considered and rejected. Now against that you did not prefer an appeal. There cannot be an appeal in sub silentio without a pleading or without a ground of challenge. If the first appellate court misses that or does not pass an opinion on that, cannot be a ground to be challenged in the in this criminal petition.
Lordship, subject to correction, even if we have not challenged specifically, it has not been a subject matter of challenge, but my humble submission is that still the appellate court has the power to decide as to whether I should be granted.
No,
the
but
benefit
you could have shown to that they have filed an application, it was rejected. Because at the appellate stage, if that is not a ground of challenge, the first question we put to ourselves is whether the appellate court is bound to take up the challenge itself by itself. You see, the first appellate court has a power which is coextensive with that of the trial court. For that, there is a provision in the CRPC. Now, before the CRPC, this plea of rejection of the plea of Provision of Offenders Act was taken and it was rejected. But then, in the absence of any challenge, can we say that the first appellate court erred in law in not considering that? This is the only question we have. We are issuing a notice, but this may not be a good ground. This is your first day. We don't want to discourage you. But this is how we got encouragement when we ourselves were beginners in the court. It's good that Mr. Biswas is giving you a chance.
Tell your name. Your Lordship, Mehul Shah, M Shah.
M. Shah, okay. Heard Mr. M. Shah, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned APP appearing for the state respondent number 1. But there's only when state respondent next para by filing this revision under section 442 read with section 438 of the BNSS, 2023, the petitioner has assailed the judgment and sentence dated 21/12/2018, passed by the Juvenile Justice Board, Bangaigaon, in JJB case number 27/18. It should be 2018. Under section 324 IPC, thereby sentencing the petitioner to be sent to a special home for a period of 4 months. Full stop. The petitioner has also assailed the judgment and order dated 27/1/2025, passed in criminal appeal number 2 of 2019, passed by the learned sessions judge Bangaigaon in criminal appeal number 2 of 2019, by which the sentence was modified by reducing it to 1 month. Next one. Issue notice returnable in. Here we don't have.
There is an IA.
Issue notice returnable in 4 weeks. Extra copy of this revision petition is out on the internet. APP within 2 days. Next one, the relevant records be called for. Both the records be called for. List on so and so, list after 4 weeks.
Lordship.
Next. But so and so. This application under section 430 of the BNSS, 2023, the applicant who is the petitioner in the connected criminal revision petition number 141 of 2025 is praying for suspension of sentence. Next is notice has already been issued in the connected interlocutory in the connected criminal petition, criminal revision petition. The court is inclined to suspend the modified sentence as directed by judgment and order dated 27/1/2025, passed by the learned sessions judge Bangaigaon in criminal appeal number 2 of 2019. Mr. Sharma, we don't need to issue notice here because only the state is here. We can dispose it off. Next paragraph, please. Ashok Ram, anything? Oh, there is a technical error. This order will not be uploaded. The this IA has not been listed. So the order will not be uploaded. In the main case, you write. It is noticed that the petitioner has also filed an IA criminal number 394 of 2025. So however, as the same is not listed, let the said interlocutory application for suspension of sentence be listed on day after tomorrow, listed on 30/4/2025. because technically it will not be uploaded. Even if I pass on, it will not be
My lord.
uploaded.
My lord, I beg apology for one thing. I think the plea of the probation can be taken up at any stage. There are judgment.
Maybe that's why we are issuing notice for the time being.
Because there are the transfer for life permit has been given by the trial judge, the appellate Supreme Court has taken this plea. That there are
No, I would have loved to have powers which they have, their lordships have. I would just love to. But I'm not very clear, therefore I'm not saying anything, but we are issuing notice from this.
Develop that.
Item 4,
My lord, the petition was convicted by the trial
But
court.
the nature of challenge, we'll have to dismiss it in limine. You are challenging the 20% order.
20% because of my personal difficulty, is unable to.
No, but that can be compensated. You take the alternative sentence. They will definitely, I think there would be imprisonment. But this 20% can't be waived. The court would have no power to waive it.
I leave it to lordship.
You close this application, you move the trial
My-
court, because this is something which can't waive. Mr. Sigdar, that part of the order is at page 35.
Yes, my lord. Order at page 30.
No, the operative part,
33, yes.
operative part is paragraph 7.
35.
Paragraph 30, page 35, para 7.
Yes, my lord.
Correct.
Yes.
Okay.
6 and 7.
6 and 7. Okay. But Mr. A.R. Sigdal and counsel for the petitioner, as well as Mr. B. Sharma, and APP for the state. Respondent number 2. Next paragraph. The petitioner is an accused in a complaint case filed under section 138 of the NI Act, which was registered as NI case number 35/2020. Full stop. The learned additional chief judicial magistrate, Porpeta, by judgment and sentence dated 13/12/2025, convicted the petitioner for offense under section 138 of the NI Act, sentencing him to undergo simple imprisonment for 1 year and to also pay compensation of rupees 12 lakh to the complainant, who is responsible one herein. Next paragraph. Aggrieved by the said judgment and sentence, the petitioner had preferred an appeal which was registered as criminal appeal number 17 of 2025. Before the in 2020 and made over to the Court of Learned Additional Session Judge, Barpeta. Full stop. The Learned Additional Session Judge, Barpeta, by an order dated 13/3/2025, passed in Criminal Appeal 17 of 2025, admitted the appeal for hearing, and in light of Section 148 of the NI Act, the petitioner was directed deposit an amount of amount of 20% of the fine awarded by the Learned Trial Court within a period of 60 days from the date of the order. Full stop. Next paragraph. That part of the order dated 13/3/2025 by which the petitioner was directed to deposit an amount of rupees 20% of the fine is assailed by filing this criminal petition, criminal petition number 471 by this criminal petition under section 528 of the BNSS, 2023. Next paragraph, the Learned Counsel for the petitioner has submitted that the case of the petitioner is that he had purchased some quantity of rice from the respondent number 1, which according to him, is valued at rupees 2,000. First of, however, the petitioner handed over 2 blank signed checks to the respondent number 1, which has been misutilized. First of, accordingly, it is submitted that that part of the order dated 13/3/2025 passed by the Learned Appellate Court on directing the deposit of 20% of the fine be stayed. Next one. The prayer made in this application, in this petition, is opposed by the Learned APP on the ground that compliance of the provision of section 148 of the NI Act is a statutory requirement which cannot be waived. In absence of any such provision, next paragraph. Considered the submissions made by the Learned Counsel for the petitioner as well as the Learned objection by the Learned APP. Next paragraph. The provision of section 148 of the NI Act, 1881 is quoted below. Next, from the above, it does not appear to the court that the requirement of a pre-deposit, the requirement of a deposit under section 148 is optional. And there's nothing in the said provision which entitles the court to suspend compliance of section 148 of the NI Act. So though it is projected by the petitioner that filing of an appeal is a matter of right, comma, for which there is no dispute. However, as the requirement of making a deposit under section 148 of the NI Act, 1881 is the requirement of law, comma, court does not find any merit in the challenge. So accordingly, there is no merit in this criminal petition. Accordingly, this criminal petition stands dismissed at the motion stage without issuance or notice on the respondents. Next para. Let a copy of this order be transmitted to the Court of Learned Additional Session Judge, Borbeta, to make it a record of criminal appeal number 17 of 2025.
Lovely.
7.
Item 7.
Wait, your lordship. Lordship, contenting counsel or Mr. Dewson is absent today. It may be absent for only today.
Pardon me?
Mr. Dewson is absent today. Due to some
Okay, you want
person-
an adjournment?
Yes, lordship.
Okay. On the prayer made by Mr.
H. Islam on behalf of Dewson.
Mr.
H. Islam
H. Islam,
on behalf of
learned
Dewson.
counsel appearing on behalf of Mr. D. Hussain, learned counsel for the petitioner, prays for adjournment.
If possible, lordship, day after tomorrow, lordship. Take turn.
Yes. Mr. MP Goswami under APP is present. List on 304-2025.
Lordship.
Supply item 20.
In this case, my lord, the petitioner initially raised objection regarding the signature, my lord, and he has categorically stated that he has not signed on the check, my lord. But and he has paid for forensic examination, but that he was not considered by the planet court, my lord, which is reflected in para 10 of the appellate court order.
10, para 10.
It can be the appellate court order, my lord.
Yes,
I'm reading.
I've read it. Yes.
And moreover, my lord,
Is the copy of that check available here?
yes, my lord, yes. Check 97 page,
Page?
97.
No, something to Mr. Goswami. See page 97. Oh, I'm sending you this record.
Yes.
See page 97 and see the page thereafter. Mr. Ahmed, if that is the only ground to make the challenge, then we may dismiss it right now.
Other ground, my lord.
What is the other ground?
Other ground is, my lord. As per allegation, the petitioner.
Now see the next page.
Petitioner took some materials, purchased from some materials from the shop of the cleaning.
See the signature is same. No, signature in the Bakra number in the first page. You are looking at wrong page.
Yes. Only to examine the forensic information. That was not considered. And other ground.
No, that if that's why we are saying if
Yes.
that is the ground that we are rejecting it right now. What is the other ground of
Other ground
challenge?
is placed, my lord. Other ground is, my lord, no, petitioner, as per allegation, my lord, petitioner purchased some materials, building materials from the shop of the complainant, my lord. And complainant has produced the original challan of the vouchers, which is, my lord, normally, my lord, somebody sold the articles, my lord, he has issued the original challan to the.
May not be always
the purchaser.
always required. No. You see, number one, have you ever deposited any challan before the treasury? Have you deposited any challan in the government treasury at any point of time? Maybe rent, maybe XYZ deposit, maybe in the court. Have you deposited? Or any money before the customs and central excise? Have you deposited? Have you seen the receipt?
I have deposited the challan in the treasury mill.
In the treasury you have deposited.
Yes. But here
Now you will always find that the treasury will keep the first copy and it will give you duplicate and triplicate. The original challan is never issued. Any government receipt, you will not get the original one, you will get the second copy.
But here is here the shop miller interpret.
We don't know that. That's why I say you wanted an example that it is normally not done. And I have a lot of experience because one part of my practice was in the trial court. Every time we have to go to court and deposit rent challans.
Original.
So original receipt is always with the authority. Second copy will go to the treasury. Third copy will go to will be kept by you. Treasury gives it, and then you make the deposit before the State Bank of India. That's the second copy. And if that is the ground, we have shown it to Mr. Goswami. Your signature in the Wakalatnama is a replication of the signature in the check. There is no difference. We have 7 or 10 friends behind you. We can take a third party opinion. The check sign in the signature in the Wakalatnama is absolute replication of what is there in the check. Nowadays it is online in the treasury. You may not be aware now, but physically when documents were handed over, it is always the first copy. Second is that if the goods are sent through bank, then all the original challans would go to the bank and not to the person. I say so because I've been sitting in shop from the age you won't even appreciate. The age when I started to sit in business establishments. You won't even think that that was the right time to handle a business. It will not be wrong to say that we were born in a shop. So that is the age from when I have been having some experience in business. I was not a successful businessman. That's why I became a lawyer. That's a different story altogether.
For good man.
Huh?
Maybe for good man.
We don't know. The only sad part is that I was not a successful businessman. If you see, there's the two parts in forensic examination. First is that your signature. You say that it was fraudulent. Signature, we don't, prima facie, we don't find it to be fraudulent. Second is,
Yes, for statement miller.
second, no, that's okay. Second part is that maybe you are seeking a forensic examination on the ground that the writings in the check, apart from the drawer's signature, is done by someone else. You see, why we are proposing that if the ground is for forgery in signature, then we'll dismiss it, is that your signature was approved by the branch, and then the checks were cleared.
As per branch
No,
manager,
that's okay.
he has not stated anything about the signature.
No, he will not say anything unless you ask him. He is the witness to be called for. Therefore, you as an accused will have a right to cross-examine. I have not seen here anything that you had cross-examined the branch manager on that, because you'd never called for the original signature card. So therefore, signature is something which is not in dispute so far as whatever is appears from the ground. Therefore, the only alternative is that we accept this challenge to the extent that the writing in the check was not by you. But for that, we have hundreds of judgments,
Yes.
even from this court,
Yes.
saying that once you give a blank document to someone, you give along with it a right to fill it up, so far as check is concerned. That was first judgment of this kind was by Kerala High Court, and it was accepted by the Supreme Court. So that ground also goes.
And as per PW1 Miller, in his cross Miller, he has stated that and normally used to issue original voucher to
The
the
customers, yes.
and that was not provided to the petitioner, and that original voucher produced by the complainant, which is not acceptable. Is it Miller? In first part. The evidence also disputed the amount.
Did you file after this complaint petition was filed? Did you give any written statement here? No.
A written statement earlier submitted Miller at the time of trial. Miller.
Where is that?
Written statement. Written statement. Yeah. I have not managed Miller. I could have done for but after
Did you give evidence? Defense evidence was led. Was defense evidence led? Ahmed, the plea which you are taking with regard to the original invoice, uh, in that context, I am asking you, have you read the evidence of the PW1? You have read it, I suppose. Have you read it or you have not read it? You're not answering.
Yes,
Now you see, I forgot the exhibit numbers, but I think more than 30 exhibits of original invoices were presented.
Yes.
Correct?
Yes.
I forgot the numbers. About 30 or something, more than 30. In respect of all the invoices, original invoices, it contains your signature. And in your cross-examination, in cross-examination of PW1, you have not denied any suggestion. Therefore, you see, when the witness says in the cross-examination, normally I give it. Normally would mean that when somebody pays cash, he gives him. But if somebody does not pay cash and signs and goes out, those invoices contain your signature. Those signatures you don't send it for forensic. You have no prayer for forensic examination for those signatures. If those are admitted, your check cannot be a check for security, but there is no memorandum drawn up for respect of that check. And second is, what will a person do with a check for security if he cannot present it and on due date? What is that arrangement? For that, you'll have to show that you have an agreement that you will not present the check, but you will give him payment otherwise. So if I have the check,
There is no agreement as per
then as security, you'll have to have some agreement, because you see PWD, when they take EMW or the security, you have an agreement with them in F2 form of contract. Then they say that this will be subject to for final adjustment and against the bills. Now you see, even in those cases, the authorities do have right to encash that security. You give it by two ways. Number one, you give it either by way of a check, which is a banker's check. Second way of granting security to PWD is by way of a term deposit receipt, which is endorsed in the name of the concerned authority. And they have a right to withdraw it. So if these are the two grounds, then we are dismissing it in limine. This revision cannot be entertained. But Mr. A.M. Ahmed, learned counsel for the petitioner, as well as Mr. M.P. Goswami, learned APP for the state respondent number 1. Next, by this application under section 438, read with section 442 and 520 of the BNSS. What is 520? Five to do is trial before High Court. BNSS. Or the petitioner is assailed. The judgment and order dated 18/3/2025, passed by the learned Sessions Judge, Chirang, in criminal appeal number 18 of 2024, by the said judgment and order, the learned appellate court had affirmed the judgment and ordered judgment and sentence dated 21/10/2024, passed by the learned additional chief judicial magistrate, Chirang, Kajalgaon, thereby convicting the petitioner under section 138 of the Negotiable Instruments Act and sentencing him to undergo simple imprisonment for a period of 6 months and also to pay a fine of rupees 17 lakh, figures and words, to the respondent number 1 stroke complainant with default stipulation. So that case number is judgment of additional chief judicial magistrate in NICR case number 13 of 2021. Thereby convicting. Next paragraph. The learned counsel for the petitioner has submitted that the case of the respondent number 1 in the complaint case was that he is the proprietor of Mrs. Rita RITA hardware stores, located at Kajalgaon, Chirang, full stop. He is alleged that the petitioner is a government contractor and had purchased G full stop, C full stop, tin sheet, TIN sheet, and cement within packet building materials of rupees 12,14,034 from the respondent number 1 on credit, write several invoices between 10/10/2020 to 10/1/2021. Stop. Against the said liability, it was alleged that the petitioner had issued a check bearing number 979879 dated 30/8/2021 against his bank account number 366-089-66105. I'm repeating it. 366-089-66105. Which was deposited by the respondent number 1 in his account maintained with State Bank of India, Kajalgaon branch, which was returned by return memo dated 22/9/2021 due to insufficient funds. Projecting that the petitioner was served with a notice dated 5/10/2021, advocate's notice dated 2021, owing to non-payment, the complaint case was filed. Next paragraph. On receipt of summons, the petitioner appeared before the trial court. On pleading not guilty, the matter was tried. Stop. In support of the complaint, the respondent number 1 had examined 3 witnesses, including himself, and had exhibited 41 documents during trial. Full stop. On closure of evidence, the petitioner was examined under section 313 CRPC. Full stop. On an appreciation of the evidence on record, the order of conviction and sentence was passed, which is referred above. Full stop. The next paragraph, the petitioner had preferred an appeal, which was dismissed. And the appellate court directed the petitioner to suffer 3 months of, modified the sentence and directed the petitioner to undergo simple imprisonment for 3 months and to pay a fine of rupees 17 lakh. With further default sentence of 3 months on failure to pay the fine. Full stop. Next paragraph. Agreed by the said first appellate judgment, the present criminal petition has been filed. Next paragraph. Referring to the grounds for this revision, the learned counsel for the petitioner has submitted that during cross-examination of PW1, the said witness had stated the PW1 within bracket complainant, stroke respondent number 1, bracket closed. The said witness has stated that whenever customers purchase materials from his store, he issues the original voucher to the customers. So accordingly, it is submitted that in this case, the respondent number 1 had exhibited the original vouchers before the learned trial court, which raises doubt with regard to the authenticity of the vouchers. Next paragraph. It is submitted that the petitioner had made a prayer before the learned trial court for sending the checks and invoices for forensic examination. However, the learned trial court, it had rejected your prayer.
Yes.
Had rejected the said prayer. Where is that? Where is that order? Where is that part of the order?
Para 10.
Para 10 of the appellate judgment.
Yes. Page 27.
Page?
Page 27.
Yes. Please give your that memo appeal which you had. Memo appeal you have.
Memo appeal, my lord.
Before the sessions court, you filed a memo appeal.
Yes, yes, yes.
Where is that?
Memo appeal. I have not any.
No, you have a copy with you definitely.
No. Thank you. What?
However, on the issue being raised to the learned appellate court, the appellate court also failed to appreciate
Sorry, Lordship.
the same in the
Sorry, Lordship. One
okay.
copy I have found.
Appreciate that and did not exercise its jurisdiction to send the checks for forensic examination. Next, it is also submitted that the check in question was issued by the petitioner as security. And therefore, the petitioner could not have been convicted on the basis of check given for security and not in discharge of his liability. Uh, uh, Mr. Ahmed, you have a copy of CRPC with you? You have CRPC with you?
No, no.
Just give him a CRPC, Criminal Procedure Code. You see, more than this CRPC, I am acquainted with the CPC more than the CRPC. So you'll have to tell us because in the CPC, whenever there is an appeal, under 107, there is a provision by which interlocutory orders, 105, the interlocutory orders can be challenged with the main judgment. Now, in the CRPC, are you permitted to challenge the interlocutory orders along with the final order? Because I don't know about the provision. At least in at least in 374, it is not there. Is there any other provision?
In the CRPC, my lord, there is no provision against the interim order, my lord. There is no any provision.
No.
Until
But then you must be permitted somewhere to challenge it. In the CPC, it is there. You can't make a challenge.
by
But then an
by way
alternative
of
is provided.
482 me.
Hmm?
If somebody will challenge, my lord, by way of 482 me.
That's why I'm pointing out this question. You see, so far as civil case is concerned, interlocutory orders can be challenged
Yes.
along with the final order. Therefore, interlocutory orders are not required to be challenged unless those orders are covered by Order 43 Rule 1. So that is the prescription of law. If there is no such provision in the CRPC permitting you to make a belated challenge to an order, every order under the Criminal Procedure Code attains finality if it's not challenged within the appropriate time, or under 482 if it's still permitted. Mr. Biswas, I just ask you something. In your case, you are referring to that provision of Offenders Act.
Yes.
Correct. Here also, please see this 374 is something for you also. I'll again repeat, I'm not aware of this power to file an appeal under provision of Offenders Act. But you see here, 374 3C, in respect of whom an order has been made and sentence has been passed under section 360 by any magistrate. 360 is order to release on probation or good conduct or after admonition. Because this doesn't cover with that. So when you address us next on that Provision of Offenders Act,
I'll be clear notice.
meet with this also.
Yes, sure.
I don't know whether I'll be hearing it, but it will be nice to hear on this point.
It will be also my privilege to be before your lord.
Yes.
Okay. Mr. Ahmed, in the trial court judgment, I'm missing this, your defense evidence. Where is that? Did you lead defense evidence? No.
No, my lord.
But then, Mr. Ahmed, if you don't lead evidence as in the defense, how do you take the plea of denial of signature without DW?
At that part, I am also confused.
Because an accused has a right to be silent. But when he remains silent,
Yes.
he has not reduced evidence to prove it, and therefore, if the forensic examination is not done,
That was raised in the trial court, madam.
oh, that's okay.
Trial court.
You-
Regarding
in
the
the-
signature,
you
preparing
see-
for signature of the examination by the forensic.
No, that's why we are asking you.
Yes.
You see, you take the plea, but don't give defense evidence. That means you yourself don't take a stand in the dock and then say, this is not my signature.
That part I have not seen in the trial court
It's not
judgment,
there.
also in the appellate, that he has adduced any defense witness.
Yes, that forensic, because accordingly, it is submitted that in the absence of forensic examination of the invoices and check, the petitioner has suffered irreparable prejudice. Full stop. Next paragraph. No other grounds for this revision has been pressed into service. Next paragraph. The learned APP has submitted that as the impugned judgment arises out of a complaint case where the state is not a party, comma, he has a very limited role in this criminal revision petition, as the state is only a formal party and he's not having any records.
No. Only thing, my lord, subject to objective correction. My lord. Here, my lord, challenge is self-contradictory is if we see, my lord, because on one hand, my lord, they say that the signatures are not his, my lord, and on other hand, my lord, he says that he is giving it for security purpose, my lord.
Oh, brilliant.
That is what
Very
I
good.
am thinking of, my lord.
Very
That
good.
everything's, my lord, settled, my lord, if we take that.
Very good. However, comma, he submitted that on a cursory perusal of the impugned judgment by the learned trial court as well as the first appellate court, comma, he has observed that the petitioner herein has taken a contradictory plea because while he disowns the signature on a check on the concerned check, but on the other hand, he takes a defense that the check was issued as
Security.
for the security as security only. Next, consider the submissions made by the learned counsel for the petitioner as well as the learned APP. You have said only one statement. Just like a nail in the coffin. Good. Also consider the materials available on record. Stop. The point raised by the learned APP appears to have some force because in paragraph 10 of the appellate judgment, the learned first appellate court had recorded that the appellant had taken a defense, that the petitioner has taken a defense that the check was not issued in discharge of a legally enforceable debt, but was rather a security instrument. Therefore, notwithstanding that the petitioner has denied his signature on the check and has prayed before the learned trial court for forensic examination of his own signature, but the fact remains that he has admitted the check to have been issued as a security. Therefore, the presumption of a validity of the signature is inherent in the instrument itself. Next paragraph. Moreover, having not found a reference to the defense evidence in the trial court judgment as well as in the appellate court judgment, on a query made by the court, the learned counsel for the petitioner has submitted that the petitioner did not stand in the witness box to lead defense evidence. Therefore, this is a case where the petitioner disowns his signature in the check, but did not give any evidence, oral evidence, to deny that the signature containing the check was not his. The court has carefully examined the cross-examination of PW1 from the nature of cross-examination of PW1, it does not appear that the petitioner has been able to demolish that part of the evidence of PW1 where he has stated that the petitioner had issued the check for a sum of rupees 12,14,034, which was returned dishonored by the petitioner's bank on 22/9/2021 by citing in inverted commas insufficient funds. Inverted commas. Accordingly, we do not find any fault with the order of the learned trial court refusing sending of the check for forensic examination on the ground that it was an afterthought, which was belatedly issued, belatedly raised, and lacked sufficient foundation. Stop. The court is not a forensic expert. First of how, on a bare perusal of the photocopy of the disputed check, which is available at page 97 of this criminal petition. The signature of the petitioner contained therein has a remarkable resemblance with the signature of the petitioner, which is available in the Wakalatnama appended to this criminal petition as well as the signature of the petitioners, which appears in the affidavit filed in support of this criminal petition. So, however, no conclusive remark is made by the court, as the court is not a forensic expert. Next paragraph. It is observed that in course of trial, the petitioner, the respondent number one as PW1 had exhibited thirty original invoices of various bearing separate serial numbers and different dates. Which are marked as exhibit P-3 TO2, exhibit P-32. To stop. The PW1 has exhibited the seal and signature of the petitioner, comma, which is marked as P3 within bracket 2 TO P32 within bracket 2, comma, in seriatim. Full stop. In the cross examination of PW1, comma, the petitioner has not been found to have demolished the disowning of his signatures on the invoices. Stop. Therefore, comma, court does not find merit in the submissions made by the learned counsel for the petitioner that in cross-examination of PW1, he has admitted that he gives the original invoice to the customers, and therefore the availability of the original invoices in the hands of the respondent number one was doubtful. Full stop. By the said exhibit P within bracket P-3 TO2 exhibit P-32 it is apparent that the original invoices were given to the petitioner, which was returned back after his signature in due acknowledgement of receipt of articles for which those invoices were issued. Next paragraph. Therefore, comma, there is no doubt that the check which was handed over to the check within bracket exhibit P-1, which was handed over by the petitioner to the respondent number one was in discharge of his debt. Next paragraph. The plea that the check was given for security is not found to be acceptable in absence of any agreement between the petitioner, in the absence of any proof of existence of any agreement between the petitioner and the respondent number one, which empowered the, which mandated the petition, the respondent number one to hold the check only as security. Full stop. Moreover, comma, the petitioner has not examined himself as in his defense to establish the said plea that the check dated 30/8/2021 was issued for security. Full stop. It is not the defense of the petitioner that the check which was issued for security was having his force, was given with his force signature. So therefore, the court is of the considered opinion that the Lara trial court had rightly refused to send the check in question within bracket exhibit P-1 for forensic examination of the signature, because the petitioner is found to have admitted handing over the check, said check to the respondent number one stop. We take the said view because if the petitioner admits that he has forged the signature and sent it to the respondent number one, comma, the petitioner would have exposed himself to the offense of forgery, which is a higher offense in with regard to punishment prescribed than one prescribed under section 138 of the NI Act. Therefore, comma, we find full. We are in agreement with the submission made by the learned APP that the plea of issuing a security check is contradictory to the stand of the petitioner that the check was issued, was not issued for any payment of any debt. Next, therefore, comma, on admission of the petitioner that he had handed over the check within bracket exhibit P-1 to the respondent number one, comma, the burden shifted on the petitioner to prove that the said check was issued for security, or that it did not commensurate to the value of the invoices. 30 invoices exhibited by the respondent number one. Next paragraph. In this regard, we find that the learned trial court has also discussed the issue by posing a question as to that as it is proved that the petitioner had issued the check to the respondent number one, then onus shifts upon the petitioner as to why he had issued the check. Full stop. The learned trial court is found to have correctly appreciated the issue in paragraph 16 of the order, where it has been mentioned that supposing if the signature of the petitioner was not in the check, comma, then the reason for dishonor of the check in the dishonor memo would have come as signature mismatch, inverted commas, signature mismatch, instead of insufficient funds. Full stop. The learned trial court has correctly appreciated that the petitioner has not denied his seal and signature over the invoices, which was duly proved by the respondent number 1. Next paragraph. The learned trial court has also appears to have correctly appreciated the issue because the petitioner had taken a plea that he took materials worth only rupees 1, 50,000 from the respondent number 1. But he changed his stand in his statement recorded under section 313 CRPC, where he took a plea that he took materials worth rupees 50,000 only from the respondent number 1. Accordingly, the taking note of some business transactions between the petitioner and the respondent number 1. The learned trial court has rightly drawn presumption under section 114, illustration F of the Evidence Act, 1872, that the common course of business has been followed in the particular case. So it may be stated that the learned trial court, while referring to the seal and signature of the petitioner in Exhibit P-2 TO T-32, has recorded a finding that the seal of the petitioner appears as inverted comma Reosil, REOSIL, next word Basumotary, BASUMOTARY, GOVT, government, full stop, contractor, class dash numerical 1 within bracket, capital A, bracket closed, full stop, inverted comma closed. And also arrived at a finding that during the trial, the petitioner has not denied that he is not a government contractor class 1, capital A. So accordingly, the court cannot find fault with the finding recorded by the learned trial court that the signatures of the petitioner over Exhibit P1, TO2, T32 stands proved. Stop. Resultantly, the learned trial court has correctly drawn presumption under section 139 of the NI Act, being a statutory presumption, the effect that the petitioner had issued the check towards his legally enforceable debt. Next paragraph. The learned counsel for the petitioner has taken a plea that although the learned first appellate court took note of the non-sending of the check for forensic examination and did not pass any order. So in this regard, it is seen that the order by which the learned trial court had rejected the prayer of the petitioner to send the checks and invoices for forensic examination have not been assailed by the petitioner. Independently. Full stop. Moreover, we find nothing in the order of the appellate court that the relevant order by virtue of which forensic examination of invoices and check was refused is put to challenge. At this third stage of the proceeding, the other two proceedings being the trial court and the first appellate court, having rejected the plea of the petitioner for sending the check and invoices for forensic examination, this court would be slow in accepting the plea of the petitioner, when he is found to not have given an evidence, at least to deny that the signatures, seal and signature at exhibit P dash 3 TO2 P dash 32 were not his signatures, or that the signature of the petitioner appearing at exhibit P dash 1 oblique 2 within bracket 2 was not his signature. In this regard, the court is of the considered opinion that signatures that when the petitioner has admitted that he has handed over the check to the respondent number 1 for security purpose, the court has to presume that the learned trial court had correctly presumed that check contained the signature of the petitioner, which was not disputed. Next para, accordingly, we do not find any merit in this criminal petition to issue notice on the respondent number 1, respondent number 2. Just a moment, let me check. Respondent number 1. Rita Hardware is respondent number 1. Respondent number 1 or respondent number 2. Accordingly, this criminal petition stands dismissed at the motion stage without issuance of notice on the respondents. Next para, the registrar shall transmit a copy of this order to number 1. The Court of Learned Additional Chief Judicial Magistrate, Chirang, to be made a part of record of NICR case number 13 of 2021, semicolon, and number 2, Court of Learned Additional Session Judge, Chirang, Kazulgaon, to be made a part of record of criminal appeal number 18 of 2024. I should be closed in view of order passed. We are returning you your memo of appeal. Item 10. Yes.
Lordship, the leading counsel, Mr. R.V. Fukun, could not come to court due to water logging in his.
Oh,
case.
okay, okay. He'll be facing difficulty, I understand.
Today,
He's, his spot is, more prone to waterlogging.
yes.
Okay. Day after tomorrow? When?
2 weeks time will be given, Lordship.
Huh?
2 weeks time will be given.
2 weeks time. There was a direction to get,
Yes, madam. Instruction I have seen,
from the traffic branch.
Yes.
You got it?
Regarding- No, man, it is also pending, man.
Okay. On the prayer made by Mr.
KJ Hazarika.
KJ
Hazarika.
Hazarika, learned counsel for the petitioner. The matter stands adjourned today. Next para, Mr. MP Goswami, learned AP for the respondent number 1. Submits that he has taken note of the directions contained in paragraph 5 of the order dated 5/12/2024, and he also prays for some time to get the relevant instructions. Next para. This one, give a date after 2 weeks.
Nice.
Item 11.
May it please your lordship. Lordship, this is a statutory appeal, lordship. In this case, this appellant has been convicted under 354 and 354A.
By
Punishment
the
is 2
sessions.
years. lordship.
By the sessions.
Yes,
Okay.
lordship.
Okay. Heard Mr. B. Chaudhary, learned counsel for the petitioner. Oh, sorry, appellant.
Appellant.
And Mr. MP Goswami, learned APP for the state. Respondent number 1. Next part, this appeal under section 415 within bracket 2 of the DNSS is directed against the judgment and sentence dated 7/1/2025, passed by the learned sessions judge, Sonipur, Tejpur, in sessions case number 85 of 2023. This will be page 1, 2023, thereby convicting the petitioner and sentencing him to undergo, it will be appellant always, appellant, sentencing him to undergo rigorous imprisonment for a period of 2 years and to pay a fine of rupees 5,000 with default stipulation. To stop, the petitioner was also, the appellant was also convicted and sentenced for committing offense under section was convicted and sentenced under section 354 IPC. And then the petition, the appellant was further sentenced, convicted and sentenced for committing offense under section 354 within bracket capital A IPC, and sentenced him to undergo rigorous imprisonment for a period of 6 months. This next one. The appeal is admitted for hearing. Next, for a call for the records from the concerned court. Got from the TCR from the learned sessions court. Next, para, the appellant shall take steps within 2 days for service of notice on the respondent number 2 by registered post with AV as well as by usual process, to be served through the jurisdictional magistrate. this, Mr. Goswami, in appeal, service is made by the sessions court or it will be by the CGM?
Lordship, this is session court.
Session tribal.
Session tribal.
No, sessions is a tribal court, but summons will serve. Trial court function ends there.
Yes.
The trial court is not a, what you call service court. So who will be the servicing court? It will be the Chief Judicial Magistrate or SDGM here? This is which police station?
It's from Lordship. Rangapara Police Station.
Rangapara.
Yes.
Jurisdiction, magistrates, oblique, sessions court, whichever, whichever applicable. With suitable modification to the form. And the learned executive court is requested to send the service report positively prior to the next date of listing. Next para. The notice is made return. As we said, issue notice. Make it returnable. Give a date after 5 weeks. Returnable on so and so. Next list on 70.
The IA is there for Lordship. He is.
IA, okay. There's a IA, heard so and so. By this application under section 430 of the BNSS, the petitioner, the applicant who is the appellant in the connected appeal has prayed for suspension of the sentence by judgment in sentence dated same copy 7/1/2020 passed and so. Next paragraph. Issue notice on this application, which is made returnable on same date. So the applicant shall take steps within 2 days for service of notice on the respond number 2 by registered post with AD. Next paragraph. As an interim measure until the next returnable date. The enforcement of the judgment and sentence dated 7/1/2025 passed by the learned sessions judge, Sonitpur, Tejpur in sessions case number 85 of 2023 shall remain suspended. Mr. Goswami, this order of suspension must be sent to the sessions court.
Only sentence has to be suspended.
No, that's right. But it copy has to be produced before that court.
Yes. Yes.
Next para. The petitioner the applicant shall produce a certified copy of this order before the learned sessions judge, Sonitpur, to bring order to the notice of the said authority. Next para, list on so and so.
Lordship, he may be allowed to remain on previous bail because that order is there on page 42, Lordship. Page 42 in IA 391, Lordship.
So, okay, then the suspension of sentence and add there, and accordingly, the applicant is allowed to remain on previous bail.
That's page 44.
42. What starting page 42?
Previous bail.
The order
dated 7/1/2025 passed by the learned session judge Sonitpur Tejpur in sessions case number 85 of 2023. Correct?
Yes, Lord.
Okay.
Highly obliged.
But you have to produce a certified copy with you, otherwise you will be arrested.
Yes. Highly obliged.
Item 12.
Item 12.
Yes.
There is also a statutory appeal, my lord.
Okay.
Against the judgment and order of sentence and conviction has passed by the learned special POCSO judge,
Okay.
Kajolgaon, my lord.
But in this case, your prayer for bail can only be considered after service of
Sentence
notice.
for three years.
So we understand.
Yes.
But after the Supreme Court judgment, where It doesn't cover suspension of sentence.
Yes.
No, it regarding at any stage of hearing that is there, my lord.
But about suspension of sentence, whether we have to pass the order after,
Perhaps.
at every stage we'll include that also.
Yes, it is. It is there.
That is the difficulty.
Yes.
The notice will go to the parent. I have informant has been made a party here.
No, it's okay. No, we are only examining the question of suspension of sentence.
To appear before them. Deadline is up to 30th. So I have to appear before the court. Then if I don't take the order, I will be sent to behind the bar.
No, but how do you interpret the Supreme Court judgment? The Supreme Court judgment says that at every stage, a victim has a right to, right to represent.
Yes.
Now, that would include, every stage would include even the prayer
Bail
for
matter,
suspension
bail.
of sentence. No, this is not bail, this is suspension of sentence.
Suspension.
Even this will be covered by that. So can we pass an ex parte order?
I leave it to your lordship. I will not
No, I
say.
don't know. We want an interpretation. You know my limitations.
No matter, you have got a.
But what we can do is that if Mr. Biswas apprehends that,
Requirement up to 3 years.
we suspend it till the next date of listing and then we hear it. We hear the respondent. 3 years is otherwise
Otherwise.
within our
Provision
domain.
is there, madam.
Yes, within the.
Old section 389. Now need to assess.
No, this, you see, the Supreme Court orders, it doesn't say about, it does not say
Yes, that's
389
not
also.
clarified,
No,
yes.
It does not,
Specifically mentioned.
but we exercise our discretion. We to protect you till the next date. Mr. S.C. Biswas, current counsel for the petitioner. And Mr. M.P. Koswami and the APP for the state. First part will be same, challenge to the order, register and so. Page 1. Judgment on order 6/3/2025, passed by so and so, so and so. Thereby convicting the appellant under section 8. It is here, for page 1 and 2. Same thing. Next paragraph.
My lord,
The
may I
appeal is
place the
admitted for
judgment,
hearing.
my lord, later judgment of the apex court on the matter.
Uh,
Regarding the period, my lord, statement.
Okay.
Suspension of sentence only.
No, suspension of sentence is there, but in POXO cases, the direction is that the victim at every stage will get an opportunity of representing. That has not been diluted by any order.
Maybe, my lord.
In every bill, every bail, criminal appeal, criminal reason, criminal petition, arising from the case involving.
This is 304 part 1.
Yes.
I have, in fact, not now.
Yeah, please. Yeah, please.
During this,
Revision bench, my observation regarding the.
no suspension, sir, but what happens to the direction of the Supreme Court on the, you see, POXO victims and the victims?
Jagdeep Singh.
Yes.
Jagdeep Singh, it is para 24. Thereafter, division bench also, our division also decided time is done. Here, Deepak Nair case.
Deepak Naik. So because that principle
Yes.
will apply in suspension of sentence on 389 also.
In every bail application, criminal appeal, criminal revision, criminal petition arising from cases involving offences under
Yes.
POCSO Act.
All
That
Yes.
is- That is what.
No, please,
Deepak Nair.
please do that. That's right. In this winter vacation, I read somewhere. I did not find the answer to this query.
Lodge.
But I was not serious about it because I had no matter in criminal side. And
Rarely my POCSO cases are below.
a
2
bit
years.
distinguished.
Yeah, 2
That's
years.
right.
man. 10 years is again.
10 years.
সদায় মানে এনেকুৱা
Exactly.
No, he's right.
Yeah.
Paragraph 24. says such victim has unbridled participatory rights from the stage of investigation till the culmination of the proceeding in an appeal or revision.
মানে পক্ষদের নোটিশ দিব লাগে সেইটো কথা কৈছিলো এতিয়া পক্ষ নোটিছ মানে আপোনাৰ 2 years হ'ব 5 years হ'ব
এটা স্পেসিফিক নেই।
নহ'লে তো দিন দিন
So what is your date for your appearance?
But the last occasion, actually, it was 6th day of March, but it was judgment announcement. So within 1 month, we have to appear. So 6th day, we have filed an application before that, that we have preferred an appeal before the High Court.
Okay. The prayer for what you call prayer for another date for appearance, that can be done, granted.
Yes, that can be
That can be granted.
otherwise. Yes.
Okay.
Yes.
We provide that protection, limited protection to you. The appeal is admitted for hearing. Call for the records. Same applicant shall take steps for service of appellant shall take steps for service of notice on so and so. Respondent number 2.
Yes.
By registered post with AD as well as by usual process to be served through the jurisdiction. No, this will be served by state.
Yes, my lord, as per the my lord decision, my lord.
Okay.
Through registry, my lord, they have to
uh,
submit.
As well as by usual process, full stop. The usual process shall be processed by the registry and handed over to the office of the public prosecutor Assam, along with a copy of the memo of appeal and the connected interlocutory application to be served to the respondent number 2 through the jurisdictional police station. The jurisdictional police station shall ensure that the service report is returned back to the court through the office of the public prosecutor Assam. Notice is made at same date, after 5 weeks, same date. Next list on so and so. In this IA, same notice. Just like earlier. Say the learned counsel for the petitioner submitted that the learned trial court had granted
till the appeal period, my lord.
Had had directed the petitioner to surrender before the said learned court. And the enforcement of the sentence was suspended till the appeal period. Next para accordingly. In the event the petitioner, the applicant makes a prayer before the learned special judge within bracket POXO. Which place?
Kajolgaon.
Kajul, Chirang,
Yeah.
Kajulgaon. The said learned court may consider refixing of the date of appearance after this. The return date is Dasji. Return date after 6/6/2025. Next one, list on 6/6/2025. Please take it back. Item 15. Yes.
Record with call for notes.
Can you copy your?
Yes, it is received. Where is your FIR?
FIR, Lordship, page number 10. Page number 13 is the charge sheet, Lordship. Page number 13 to 22.
Whether your service is complete, not the record is received.
Record
Records were called when?
on my lot 28.
Lordship,
6/3.
6/3/25. Lordship, more than 6 weeks have passed.
You can't help it.
Lordship, summons are being issued again.
You produce a certified copy of this order before the trial court. They will send the records on the basis of this. For some reason, it has not reached the.
Lordship, I have a certified copy of them.
Produce it before the trial court. The fresh order we are passing, please produce before the trial court. Send the records. Scan copy of the records. Your name is NJ Daimari.
NJ Daimari.
But Mr. NJ Daimari, Land Counsel for the petitioner. So he has pointed out that despite the requisition for records being issued, by office note dated 12/3/2025. Scan copy of the records have not been received by the registry. It is also pointed out that the notice on Respondent number 2 is also not been served. In spite of notice being issued as per office note dated 4/4/2025. Next para. It is reiterated that not reiterated, it may be mentioned that by order dated 6/3/2025, comma, the court had directed the registry to take steps for requisitioning the scanned copy of the case diary. Where is the charge sheet? Charge sheet file.
13 Lordship.
Page
13.
13,
13 to 20.
13, madam.
13 is the type copy Lordship. It's on page 15.
It will never come. You see, this case diary is not a part of the charge sheet, so it will never come from the trial court. Can it come? I don't find a reference to the case diary because it's not sent. You see, the case diary is sent only prior to the charge sheet.
No,
In the charge sheet, only those materials will be available which are filed along with the charge
Along
sheet.
with the
Case
charge
diary is not mentioned here to have been filed. Because this is case diary can always be called for under
yes,
173.
because normally, my lord, if search sheet is not, my lord, investigation is not pending, my lord, then they
No, charge sheet means that the investigation is completed.
Yes, my
So
completed.
charge sheet will only contain those documents which are mentioned in the charge sheet.
Yes.
Is case diary available here? No. So it will not come. It is only for the court to call for from the IO under 173. I think 173 or maybe one or two here and there. One 172. So 172(2). Any criminal
Yes.
court may send for police diaries
That.
in case of inquiry or trial, and may use such diary not as evidence in the case but to aid such inquiry or trial. After that, you remember after the deliberation only the CCTNS was implemented.
Yes.
And in CCTNS the charge sheet has no place.
Yes.
So we can now only look at the materials which are available in the charge sheet. And all those things are here. They are available at page 21, 22, and 23.
That's
So, Mr. Devani, we do have no need of that case diary. Because so far as I am concerned, I never look at the case diary when I am looking at the charge sheet. You are asked for questioning of the FIR.
Yes, Lord Chair.
No, in that the charge sheet is not even required. But yes, notice is to be served on the complainant. I think
Yes, Lordship, we have taken steps.
we understand. But the steps was wrongly issued through the jurisdictional, what do you call, to the district magistrate. Mr. Sharma and Goswami,
yes.
whenever you are there in assisting the court in the trial court, when the orders are passed,
Yes.
I hope you are aware what is happening. I told earlier also. You see, this criminal forms are in part 2. Yes. 35. Give it to him.
Lordship has indicated earlier.
Yes.
Yes.
Just
Lost.
refresh your memory.
Lordship.
You see, this was long back when we did not have a CRPC and our own Jari system.
Yes.
The process was used to be sent to the DM.
Yes.
Now DM does not have a robust Jari system.
Yes.
Therefore, we depend on our own process servers because now every district in the establishment of CGM and in the establishment of the district judge, we have a process servers. In this case, the going by the form, it has been sent through the DM. You will notice that whenever I dictate the order, I always say that through the jurisdictional magistrate
Jurisdictional based.
with notable with suitable correction to the form. That's why I always put it. Just render that part of assistance when the courts are passing orders.
Lost.
Also discuss in your office if there is any other alternative way, because you'll be able to collect information with regard to the DM's office in a more better way than us. Because when you are present, the government advocates are not there. So therefore, I can't know from the government advocates because you are here. Please find out from your office how they do it. Next problem. This sentence is complete. Okay, next paragraph. Insofar as the case diary is concerned, comma, it is observed from the contents of the charge sheet available at Annex 2 of this petition. Which does not state that the case diary was submitted along with the final police report form. However, it appears that now under this, which are the documents you're relying? Come to page 18. Enclosures, you see, come to page 19.
19 last part.
Last page, para 20.
Lordship 20.
এখন ঘটনাস্থলীর মানচিত্র
মানচিত্র
তিনিখন
তিনিখন
জব্দনামা
জব্দনামা ইমানখন জব্দনামা
হ্যাঁ
আৰু এখন পশু
আমার তো
ডাক্তৰৰ চিকিৎসা
দুইখন not two, three, it is overwritten as three.
yes
তিনিখন জিমানামা
নিৰ্মাণ।
আৰু এখন
পশু ডাক্তৰৰ চিকিৎসা
তারপরে রয়েছে
ও
মূল্যর
মূল্যৰ
প্ৰতিবেদন।
প্ৰতিবেদন।
One scissor list is here at page 20.
Lordship.
Third is such and scissor. This is interception. The documents are not there. Scissor is third scissor list. Jivanama is not there. So how at paragraph 20 of the final police report form, the documents enclosed to the charge sheet are number one sketch map of the place of incident, number two, 3 scissor list, then comma number 3 Zimanama, ZIMMA, NAMA, next word, comma, and 1
medical certificate
from the veterinary doctor with its valuation.
valuation of the cattle
Valuation with its valuation.
cattle's valuation
Huh?
valuation of the cattle's
Valuation.
মূল্যৰ প্ৰতিবেদন
Protibedan is
report
report.
report
With valuation report.
valuation
With valuation report. Expert accordingly. As the only materials which can be examined for the purpose of quashing of the FIR would be the documents which are enclosed with the final police report form. Next para accordingly. That a requisition be sent to the court of the London, which court?
SDJM Koliabor.
Subdivisional judicial magistrate, Koliabor, Nagaon,
কলিয়াবৰ নগাঁও
to send the scanned copy of the final police report form and all enclosures annexed thereto. stop. Moreover, comma, if that moreover, comma, in the event the in the event the police has also submitted copy of the case diary, comma, scanned copy of the case diary shall also be sent. So, however, comma, the registry, comma, upon receipt of the case diary, shall keep it in a sealed, scanned copy of the case diary, comma, shall keep it in a sealed cover while sending it to the court. Next, further. We noticed from the office note dated 4/4/2025 that the notice to the respondent two was sent through the district magistrate, Morigao. Under under such circumstances, comma, the court is inclined to direct the petitioner to take fresh steps for service of notice on respondent through. The registry shall send the process to the jurisdictional magistrate for being jurisdictional magistrate. Who is this Krishna Gogoi in the FIR? Where is the FIR?
Page 10.
Page 10.
Lordship is the complainant.
No, but he's a police person. Look.
But my lord, he was named by,
I understand, but he is in the police check post.
he is the informant.
He's the informant, Lordship.
So this will never be served. You send this, where do you get this address of the complainant?
Lordship, it is given in the charge sheet itself. Sorry, in the FIR. Page number 12. Page number 12.6 with the asterisk. Complainant information, Sri Krishna Kumar Gogoi, son of late Uttara Gogoi.
But he's a police personnel, he will always be in duty. He will not be served with a summons of that place. So the judicial vision, full stop. In addition, the petitioner shall also take steps for service of notice on the respondent number 2 through the officer in charge of Kolyabar police station. As at the relevant time, the respondent 2 was serving in the Silghat police check post on at the relevant time, i.e. 3/11/2023, the respondent 2 was serving in the Silghat police check post under Kolyabar police station. After processing the steps, the same shall be handed over to the office of the public prosecutor of Assam for transmitting the same to the Kolyabar police station through the VHF facility available in the court for onward service to the respondent number 2. full stop. The concerned police station is requested to send the service report to the court through the office of the public prosecutor, Assam. Next matter, the notice is made returnable on 3/05/2025. So list accordingly. Next matter. Just before the last line, you say, in order to expedite the transmission of the scanned copy of the records called for, the court permits the learned counsel for the petitioner to provide us, to produce a certified copy of this order before the court of, which court?
SDGM Kolia.
The Court of Subdivisional Judicial Magistrate, Kolia, so as to enable the said learned court to send the scanned copy of the records as requisitioned. Next para list on so and so. There is a certified copy. I think 2 or 3, you are sitting there. I really don't have the energy to take up any other 2 matters. There are item number 16 and 21 left. I'll be adjourning this. Item 16 and 21 pass separate orders. Both sides are represented. So as it is already past 5 o'clock, 5 p.m. The matter stands adjourned today, as it could not be taken up due to paucity of time. Next para list on
21. I'm 46 here.
16. Yes. When?
Next week.
Next week. We'll fix it on Monday next. List on. No, Monday's 5th. 5/5/2025. And item number 21.
May 2nd of May, Mala. If this May.
2nd of May. Okay. 2nd of item 21, 2nd of May. Okay. I'm sorry, but I could not help it.
Mala.
You're also there. For which item?
Yeah, for the action number 17, hearing method.
Oh, that will be adjourned. 17? 17 is not there. 17 is not available. Oh, achha, hearing matter. Okay. Okay. 17. When do you want? When do you want?
After vacation, summer vacation.
That will be too long because it's fixed for hearing a 2012 matter. 2012 will be too long. There's also Micah appointed.
Yes.
You are there, Mr. Das. Okay. So why you were appointed, Mr. Das, when
I have spoken in 2 or more occasions when he was absent.
was absent? Okay. Item 18. 17.
17.
Since as it is already past 5 p.m., due to positive time, matter could not be taken up for hearing. Next, this being a 2012 matter, list on 6/5/2025. Any other matter left out? 18. 18 also.
Hearing matter.
18 also hearing matter.
Right.
Same. No, second of. Civil bench or as a matter. Five. Okay. Any other matter left out in hearing? 6/5.
No.